everybody online ready?
And we also have Director Castle.
Okay, perfect. Okay, so we are calling to order the Corrections Policy Committee meeting today. Today's August 12th, 2025, and it's 10 a.m. and we're at the DPSST building in Salem. We need to do the public meeting statement announcement. So this is let's read it off this one. This is a public meeting subject to public meeting law and will be recorded. Deliberation of issues will only be conducted by Corrections Policy Committee members unless permitted by the chair. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence proves a safety risk to the other persons in the room and makes it impossible to continue the meeting. Okay, so we'll do introductions.
And I can go ahead and start this off
Yes,
for
you-
We'll begin with you, Chair Cameron.
Okay,
All you have to do is state your name and who you represent for your position.
Yes, Jennifer Cameron, and I represent non-management parole probation.
Member Aldridge.
Josh Aldridge, Jackson County Sheriff's Office, representing the Jail Command Council.
Member Bourne.
Mark Bourne, public member.
Member Bowden.
Margo Bowden, non-management corrections.
Member Frasco.
Lori Frasco, Department of Corrections, AFSCME.
And then online we have Member Frost.
Non-management corrections for AFSCME at Snake River.
Thank you. Member Hartford.
Mike Hartford, representing the Oregon Association of Community Corrections Directors.
Member Hunter.
Nick Hunter, representing the Oregon State Sheriff's Association.
Member Langley.
Ted Langley, Lane County Sheriff's Office, representing Jail Command Council.
And then online we have Member Mays. Member Mays, can you hear us? No, let's come back to him. Member Tabor.
John Tabor, Professional Development Unit Administrator for the Department of Corrections.
Member Mays, are you back? I guess not. For staff introductions, Juan Lopez, Executive Assistant, DPSST.
Eric Riddell, Criminal Justice Support Specialist, DPSST.
Jennifer Lavario, Professional Standards Compliance Coordinator, DPSST.
Kathleen Calpine, DPSST.
Marie Atwood, Professional Standards Division Director, DPSST.
Kathy, I think you gotta get your title on there now. It only makes sense.
I'll work on it. I'll work on it.
Melissa Langacho, DPSST coordinator.
And then
Justin
online,
Wall.
if you can hear us.
Yeah.
that to me?
can you hear me? Is that a yes or a no?
Yes, we can hear you.
Okay. Okay, there we go. Justin White.
Director Castle,
Yep, Phil Castle, DPSST.
thank you so much. And I believe we also have Bree Murphy online.
Bree Murphy, DPSST.
Thank you. Back to you, Chair Cameron.
Okay, do we need to introduce the people in the back?
Oh, the rest of the group.
Park, DPSST. Jennifer Howell, DPSST.
Hamilton, Criminal Justice Compliance, Criminal Justice Certification.
Hey, good morning, everybody. Welcome. The first item up will be the approving the May 13th, 2025 minutes. Has everybody had a chance to review them? Online, yes. Were there any requested modifications? If not, we'll look to confirm consensus and approve the meeting minutes. Hearing none, does everybody approve the minutes? Shake your heads. Yes, yes. So it looks like we have a consensus, so the meeting minutes from May 13th are approved. Next, we'll head into administrative closures. We'll turn it over to, I believe, you, Jennifer, to take charge of that.
Thank you, Vice Chair Cameron, and committee. Jennifer Lavario for the record. We did prepare 4 administrative closures for the committee today, which are to be ratified by 1 vote. The department may recommend administrative closure of discretionary professional standards cases to the committee when we determine that the conduct being reviewed does not meet the statutory and administrative rule requirements for denial or revocation. Vice Chair Cameron.
Are there any questions or discussions regarding the administrative closures that anybody has? Online? No questions? Okay. And any other recommendations with that? None? Okay. Then we will call for a motion to approve the consent agenda as presented, or as modified. Do you call that?
Gotta do the motion.
Oh, we have to do the motion. See, this is my first time chairing this meeting. I will
Nick
get
Hunter, for the
there.
record, so moved.
Josh Eldridge, I'll second.
Okay, so we have a motion to approve the consent agenda.
All right, we are voting on a motion to approve the administrative closures. Vice Chair Cameron?
Aye.
Committee Member Aldridge?
Aye.
Committee Member Bourne?
Aye.
Committee Member Bode?
Aye.
Committee Member Fasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays? Committee
Aye.
Member Tabor? Thank you. Committee Member Tabor?
Aye.
Motion passed.
Okay, next we're gonna move into the professional standards case reviews. We have, one in-person, testimony, which is, Ms. Padilla, and then a virtual, which will be number 4, no, never mind. We're not gonna, hear the case against Bonnie Kessel, so that one we can take off. Then we have the in-person, which is, Ms. Padilla, that's, item number 7, and then number 11 is a virtual, which is Justin White. So we're gonna skip to 7 and then go to 11, on the agenda.
Madam Chair, can I ask a quick question
You
on Bonnie
absolutely
Kessel,
can.
why that one was removed? Because we moved that one from the last one to this one.
And I cannot answer that, so I'm sure somebody that knows will.
Marie Atwood, for the record, I can answer that question. We inadvertently gave Ms. Kessel the incorrect date. So rather than assume she would be here and not give her the opportunity to be heard, we're just gonna bump her to the next session.
Thank you.
Yeah.
Okay, so go ahead, Jennifer.
I believe Juan may be out getting Ms.
Okay.
Padilla because she's here with a couple of
Okay,
guests.
so we'll, have her come in and go from there.
Yeah.
You can sit in the very first seat, and then
Good morning, Ms. Padilla.
Good morning.
Thank you for coming in today. You'll have 5 minutes to explain your mitigating rules, or mitigating statements, and Jennifer Lavario will explain the rest from here.
Thank you, Chair. Ms. Padilla, we talked in the outside for a moment about what's gonna happen. What I'm gonna do is present the case and then you'll be given your 5 minutes. Okay? Jennifer Lavario for the record. This case is about Hurlit Padilla. The department opened a professional standards review after receiving information that Hurlit Padilla was charged with driving under the influence of intoxicants and reckless driving on February 9th of 2024 in Clatsop County. On January 24th of 2025, Ms. Padilla entered a plea of no contest and was convicted of DUI and sentenced to 18 months of bench probation, to include a driver's license suspension until January of 2026. Ms. Padilla is currently employed by the Clatsop County Sheriff's Office. The department's review determined Ms. Padilla did violate FOR's moral fitness standards for misconduct. Ms. Padilla engaged in misconduct when she violated criminal law, pled no contest to, and was convicted of driving under the influence of intoxicants. Ms. Padilla engaged in misconduct when she drove her vehicle while under the influence of alcohol, which threatened harm to others and property. Ms. Padilla engaged in misconduct when she harmed the efficient operations of the Clatsop County Sheriff's Office by engaging in criminal conduct in the jurisdiction in which she worked, which violated the Criminal Justice Code of Ethics, the public's trust, and the integrity of the Sheriff's Office, which led to a last chance agreement to prevent any future harm. Ms. Padilla, are you prepared to provide your statement?
Yes.
Just a word of caution that we won't be having any questions or answers during the 5-minute period, and I may give you a 1-minute warning if we get to that point.
Okay.
Okay? Whenever you're ready.
Okay. So I was just going to start by reading a letter from Warriors Heart, which is a inpatient treatment facility in Banderas, Texas. I was not able to attach it to the previous email and submit it before July 7th. Says Hurlett was admitted to Warriors Heart on March 24th, 2024 to complete the residential inpatient treatment program and was successfully discharged on May 8th, 2024. Warriors Heart is a private treatment facility for first responders, veterans, military, and law enforcement officers. Our team provides our clients with the best treatment in the field as we specialize in private and confidential substance, alcohol abuse, addiction, and co-occurring psychological and moral injury. Each client is assessed for both mental and health and medical conditions and given their own customized treatment plan. The course includes the 12-step program CBT, which is cognitive behavioral therapy, cognitive restructuring, trauma treatment such as EMDR, which is eye movement desensitization and reprocessing, chronic pain management, harm reduction, examination of triggers, anger management, relapse prevention, aftercare narrative therapy, nature hikes, life skills and resilience building, family couples counseling, canine art therapy, and the Middle Shop Blacksmith. They are located at 543 Acre Ranch in Banderas, Texas, which was carefully selected because it provides serenity, space, and still within the cities and amenities. Our model at Warriors Heart is to allow healing in a home-like environment. Healing will uncomfortable at times, but recovery should also feel good. Warriors Heart creates a space that looks and feels comfortable and fosters the healing process. During her Let's Stay at Warriors Heart, she participated in elective programming to include woodshop, jiu-jitsu, and training in the service canine she adopted, she took and took home. For at least 1 week in each capacity, Hurlett also received the Warrior Community as the LS campus team lead and canine team lead during her stay. And Hurlett completed all clinical assignments and met all benchmarks for successful completion of the program. I just wanted to read it out loud to show some of the programs there. And I did also I did enter Warriors Heart, actually right the same day as the incident that was put on administrative leave. I did call Warriors Heart and registered for the program. Some of the obstacles, hurdles since the incident have been the legal case, which has been very challenging because it's public and having to explain that to my children as well was challenging. And being in the public, especially with the social media platforms available that became, available and was actually very, I don't even know the word for it, being scrutinized by the public for what I've done, which was like being a disappointment all over again. But that's something that I have tried overcoming because there is still a webpage or social media page that completely has it still posted up there. It has my face, it has my pictures, it has all my legal information on there. And just having some of that criticism from the public, it was really rough. But I was more worried about how it's affected my children as well as my employer, having that been brought up again. But just knowing that my children were actually proud of me, wanted to stand up for me because I've known what I've gone through and how I started, what it was like for me drinking, and how I am now having that sobriety now.
1 minute. 1 minute remaining.
Left? Okay. I have also like obstacles, like friends passing away, my child being in a car accident here in June, and in July my dad being diagnosed with cancer. Like those are things that I would normally would have put me into an environment where I feel like I would have had to drink just to be numb and forget some of those things going on, but I haven't, and that's huge because that was my go-to. That's my comfort. So I feel like I have improved. I have done things to do better. Currently doing my community service hours at an entity that helps the homeless, but also want to continue to do that even after my community service hours because it helps more of the vulnerable people and those that have also their own substance abuse problems, and just being able to build that rapport with them makes a difference. So.
Vice Chair Cameron?
Thank you for the information. Now we're gonna move forward and ask for consensus of the committee to adopt the record regarding Ms. Padilla's case, or return it for any other information. We have to make a motion for that, I do believe. No, because the consensus, that's right.
Sorry.
Okay, so that's just any objections to moving it forward at all? Okay, so we have a consensus for that. So we've adopted the record. So we're good there. I'm walking through this the first time, so bear with me. So now we'll open it up for a discussion of aggravating or mitigating factors. So please state your name and identify your aggravating or mitigating factors in this case.
Nick Gunner for the record. Aggravating factor is the previous DUI. The previous DUI was before employment with Clatsop County Sheriff's Office, but that does exist as another criminal charge where potentially the public was put into harm by actions of Ms. Padilla. On the mitigating side, mitigating factor is Ms. Padilla being here today, accepting responsibility and providing mitigation, and it's also a mitigating factor that Sheriff Phillips is in the room in support of Ms. Padilla.
Thank you.
Ted Langley for the record. One of the circumstances that I thought was aggravating was the fact that while her training record is not extremely long, just because of her time in service, there is ethics training on there, and ethics training is supposed to create a foundation of being ethical and help us learn how to do that. And I feel like in this case, the fact that there was ethics training given and she was maybe still unable to identify that what she did was unethical. On the mitigating side, she was honest with the deputy that pulled her over initially as far as whether or not she had been drinking. And I also found it mitigating that the office was also willing to allow her a last chance offer.
Thank you.
Josh
And-
Aldridge for the record, mitigating circumstance. Ms. Padilla sought out treatment, and it sounds like has been fairly successful in treatment immediately following. Additional mitigating circumstance, piggybacking on Commander Langley's comment about cooperation, even the arresting officer in his police report mentioned that Ms. Padilla was cooperative, didn't try to use her position in law enforcement to gain any advantage.
Thank you. Anybody online? Not seeing anything. Anybody else have any?
Nick Hunter for the record. Mitigating circumstance throughout the what was a fairly extensive internal investigation. It appeared that Ms. Padilla was forthright with information, was cooperative with investigators. It appears to be a fairly tight-knit family where others could have said them something or used influence or other things like that, and it didn't seem like that during the investigation. It seemed like everybody was forthright with information, which really highlighted Ms. Padilla's problem. that she's chosen to address. And I think I would almost, and it's probably an odd in this situation, but second, the mitigating factor that Josh brought up, that quite simply choosing to put yourself into treatment and to actually address the root of the problem.
Thank you. I'd like to add, Jennifer Cameron, for the record, I want to add one mitigating factor that she stated when she was going through some hard times, that she went back to her treatment and she made it through those times staying sober, which I think is a positive for her, showing that she's gained some knowledge from her treatment. Anything else from anybody? You want to go ahead and let us know, recall
Sure.
all those?
Thank you, Vice Chair Cameron. Jennifer Labario again, for the record. For aggravating, I have, there was a previous DUI before she was employed with Clatsop County, where the potential for public harm was, could have occurred. Her training record, this is also aggravating, indicates that there was ethics training that she would have gone through, which should have helped her learn how to be ethical. But in this case, it seemed as though she was unable to do that. For mitigation, she accepted responsibility for her actions. Sheriff Phillips is here to support her. She was honest with the deputy who pulled her over, and that deputy also mentioned that in his report. The last chance agreement that the agency allowed her to take part in is also mitigating. She did seek out treatment on her own. Throughout the internal investigation, she was forthright and cooperative, as well as the agency was forthright. Everyone there was forthright in that investigation. Choosing treatment to address her root problems was mitigating, and when she went through hard times, she also went back to treatment to try to address some of those issues.
Josh Aldridge, for the record, one point of clarity. The deputy who initially pulled Ms. Padilla over and the officer who wrote the criminal report are two separate individuals.
Thank you.
Thank you, Jennifer. Excuse me. So we need to have a consensus that we've identified all those factors, that she's got all those, okay. Then we want to open for discussion about whether there was a moral fitness violation. Remember, with her, the allegation is misconduct, which carries a 3 to 10 year ineligibility period, so letting you know that. And do we need to affirm, is that a vote? Okay, so we need to have a motion to affirm the mitigating and aggravating factors as stated. Is that right?
It's
No?
just to
No.
affirm, negate, or modify the moral fitness violation.
Oh, okay, so that would be the,
Consent voted
okay,
Madam
okay.
Chair, Nick Hunter, for the record, I make a motion that we accept the DPSST staff report
There we go.
identifying those between dishonesty, misconduct, and the third one, which I'm going to lose my mind right now, misuse of authority, accept that as DPSST prepared it.
Thank you.
Josh Aldridge, I'll second.
Now we can have a vote.
Right, we are voting on a motion to affirm the moral fitness violations as presented. Vice Chair Cameron.
Aye.
Committee Member Aldridge.
Aye.
Committee Member Boren.
Aye.
Committee Member Bowden.
Aye.
Committee Member Frasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, so the next step is we need to have a motion. No.
Madam
Yes,
Chair, I'll-
okay.
Nick Hunter, for the
Yeah,
record,
thank you.
I'll make
I'm
a
getting
motion
through.
that we take no action in this case.
Mark Foran, for the record, I'll second.
Yes. You
Right.
need to state why you're recommending that.
Oh, thank you. See, good clarification. He's over there figuring it out. Nick Hunter, for the record, make a motion that we take no action in this case, although we have confirmed or substantiated the moral fitness conduct. I believe that the mitigating factors, the steps that Ms. Padilla has taken since this incident to truly address the SUD portion of it and make those changes to become a more positive influence within not only our own agency but in the community would be the reasoning for taking no action.
Thank you.
Mark Bourne, for the record, I'll second for the same reason as Sheriff Hunter.
All right, we are voting on a motion to take no action. Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bourne?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Tabor?
Aye.
Motion passed. Thank you, Ms. Padilla.
Thank you.
for your time.
That's okay, I'll figure it out by the end of this thing. It's all good.
You're doing great.
I was gonna say, Nick's got it.
I know, and I appreciate that. I will have his back too. Okay, next we're gonna go to the virtual testimony with Justin White. Is he on?
Mr. White?
Yeah.
Jennifer, you wanna take over?
Sure. Justin, you have a representative.
If you're talking, you cut out, I can't hear you.
I'm sorry, I just want to identify your representative here today. Do you have someone with you?
Correct, that would be legal representation, Mr. Peter Drunkenmiller.
Thank you. Okay, so I'll begin with the review of the case. I'll let you know when it's time to provide your verbal mitigation. This case came before the committee last quarter. I believe everyone here may have been on the committee, but I'm not certain at that time. The reason we're back here today is to provide Mr. White the opportunity to give his verbal statement because we gave him the wrong link to do so last time. So the case is, we opened a professional standards review after Justin White was terminated from the Oregon Department of Corrections Two Rivers Correctional Institution on April 10th of 2019. Mr. White was terminated for declining to fulfill an overtime request and receiving under the influence and reckless driving charge in Washington State on November 10th of 2018. Mr. White grieved his termination and it went to arbitration. The arbitration resulted in a decision by the arbitrator that although Mr. White did engage in misconduct, the Department of Corrections did not employ the proper progressive discipline process. Therefore, he was reinstated to employment. While reviewing the separation of Mr. White, the department became aware of a criminal disposition that Mr. White did not report to the department while he was employed at the Department of Corrections. Mr. White was cited for failure to stop, give information, or aid, a misdemeanor, on March 12th of 2016. This case was diverted and subsequently dismissed on June 13 of 2017. On November 17th of 2021, Mr. White pled guilty to reckless driving, an amended judgment from the original charges of DUI and reckless driving. On September 3rd, 2022, Mr. White was transferred to the Eastern Oregon Correctional Facility where he is currently employed. The department's review determined that Mr. White did violate the board's moral fitness standards for misconduct. Mr. White violated criminal law while employed as a corrections officer and admitted to driving while under the influence of alcohol. Mr. White's conduct threatened harm to people and property and violated the Criminal Justice Code of Ethics. Mr. White violated several laws while employed as an officer which threatened harm to people and property, the totality of which, along with DUI and reckless driving, evidenced a disregard for the traffic laws of both the state of Oregon and the state of Washington. As a corrections officer, Mr. White was responsible for holding adults in custody accountable for their actions related to rules and laws. Corrections officers are expected to provide an example of behavior that aligns with sound judgment and rule-abiding behavior. Vice Chair Cameron. Oh, I'm sorry. Got ahead of myself. Excuse me for that. Mr. White, are you prepared to provide your statement?
Sorry, you're cutting out. What did you say?
Would you like to provide your statement now? I can start the clock.
Yes, ma'am, but I just want to confirm, we are talking about the reckless, the DUI arrest, the refusal of overtime, and those are the other two, correct?
At this point, we are providing an opportunity to provide mitigation based on the staff report that we presented to the committee.
Right, and you're kind of been cutting out, so can you repeat what the basically what the allegations are, please?
Vice Chair Cameron, would you like me to go over those again so he can hear them?
Yes, please. Can you please do that?
Yes, please, really quick.
So if I can get a position where you can hear me better. So the department determined the moral fitness violations were for misconduct, that you violated criminal law, employed as a corrections officer, and admitted to driving while under the influence of alcohol, that your conduct threatened harm to people and property and violated the Criminal Justice Code of Ethics, that you violated several traffic laws while employed as a corrections officer, which threatened harm to people and property, the totality of which, along with DUI and reckless driving, evidenced a disregard for the traffic laws of both the state of Oregon and Washington. As a corrections officer, Mr. White was responsible for holding adults in custody accountable for their actions related to rules and laws. Corrections officers are expected to provide an example of behavior that aligns with sound judgment and rule-abiding behavior. Were you able to hear that?
Yes, ma'am.
All right, are you prepared to provide your statement?
I'd like to remind him that he has 5 minutes. I don't think he's been informed of that.
Mr. White, you know you have a 5-minute time period?
Yes, ma'am.
And we won't have any questions or any question period time, so I want to make sure that you're aware of that too, Mr. White. It's just your statements.
Okay.
Thank you.
And I may give you a 1-minute warning, so you know where you are, okay?
Okay.
All right, you can begin.
Okay, so to begin with, I actually do have documentation, and Ms. Lavario, I gave you all these documentations for the failure to give info for A, where I was the victim of the accident. I actually my collarbone was broken in 3 spots. I don't know if you can see the scar here. If you can't, here's the bracket that was holding it in place. I was the victim of that accident. It was dismissed with prejudice. Concerning with the DUI arrest in 2018, I also have documentation that I did call DPSST and I did report this. When I discussed this with the old business agent, Roger Ware, I informed him, I was told by someone at DPSST that unless this DUI is a conviction, I do not have to self-report. If I'm still going to fight it, keep them updated. That's what I was told by your people at DPSST. So I did self-report that back in 2018. Regarding that DUI, yes, I did. I did it. I completed all sanctions that were imposed upon me by the court of Tri-Cities, Benton County. All fines, classes, that was all done as soon as possible. So as far as the failure to give info or aid, again, I was the victim in that one. I'm not sure what else to tell you on that. think there was another one from the other meeting about speeding on a motorcycle. During that time frame, I was not employed by the department. I'm not sure why that was being brought up. I was exonerated of that, or not exonerated. I was pulled over. You know, I got a ticket for that, $1,100 ticket from that. Hold on. Getting a connection notification. I received a traffic violation for that. Speed for the motorcycle. Paid it off. I did everything that was mandated of me. Yeah, I'm not sure what else to tell you. I mean, everything that's there as far as refusing overtime. I came in the day before. I had a known history of doing overtime at TRCI. And also concerning the arbitration for the wrongful termination, the arbitrator also stated in his notes, I was fired for reasons not stated. There was documentation of management at TRCI that they were being dishonest, intentionally dishonest with their paperwork. And that's it.
Thank you.
Thank you, Mr. White. We will move forward, ask for consensus of the committee to adopt the record or return the case for any additional information needed. So committee members, just if you want to adopt the record or return it to staff. So we're good to adopt. Confirm that the consensus to adopt the record is approved. Are there any objections? Stating none. We'll move forward and we'll open the case for discussion. Remember to state your name and identify any aggravating or mitigating factors.
Mike Hartford for the record. More of a clarification. We did review this case last time. In the minutes, there's several identified aggravating and mitigating factors. Can we just reaffirm those?
We'll need to repeat them on the record and then go from there.
Understood.
Since we're kind of starting over in some respects.
Gotcha.
Ted Langley for the record. Now I'm gonna ask for clarifying. So are we saying that the aggravating factors that were identified previously we're just gonna completely redo that?
We just need to repeat them on record now,
Okay.
if that's what
Thank
people
you.
still think.
Thank you.
Mike Hartford for the record. I can read them.
Please do.
Thank you. The aggravating factors were: the two criminal convictions show a pattern of behavior with a significant time between the two incidents. There was dishonesty in the 2014 reckless driving incident. I apologize, I'm reading the wrong one. Aggravating factors: White's numerous traffic violations after his conviction showed disregard for the law. His mitigation letter did not include any responsibility for his actions, and he blamed others. White has taken no accountability for his traffic law violations, which continued into 2024. White has exhibited a pattern of disregard for the laws of the state of Oregon and the state of Washington. Driving 102 miles per hour on a motorcycle is putting the public in significant jeopardy with disregard for human life. The arbitrator's opinion relating to reinstating White's employment relied on procedural issues, and the arbitrator affirmed that White engaged in misconduct. White's criminal conduct is aggravating. White did not report his criminal conduct to DPSST or the Department of Correction appropriately. White's failure to report his criminal conduct could be considered dishonest, but not a moral fitness violation as outlined in OAR. The mitigating factors: the committee did not identify any mitigating factors.
Thank you.
Nick,
Josh.
oh, go ahead, Josh.
Josh Aldridge for the record. I know we mentioned the lack of accountability in the mitigation letter. I want to add to that was my observation today of Mr. White's statement. I didn't hear any accountability. The closest thing I heard was a "yes, I did it" comment. Instead, I heard a lot of blame pointed in the direction of other people involved with the situations.
Thank you.
And Josh, just for clarity, that was an aggravating factor.
Yes, aggravating factor. Thank you.
Nick Hunter, for the record, aggravating factor. I want to go back to that piece on dishonesty and actually go to a comment made by the arbitrator. The arbitrator in his report made the comment, through the events leading to this hearing, referring to Mr. White, an impulse to tell a different story at different stages of this matter. I believe the aggravating factor here is dishonesty. And so we can call it what the arbitrator did, which was storytelling, but specific to the incident on November 9th and November 10th, and then what the excuse that he provided during the internal investigation involved dry heaving, nausea that he didn't have medication for. The excuse that he provided to the arbitrator during the formal arbitration was that he had experienced his stepfather losing his job and his stepfather then having suicidal thoughts, and this is why he couldn't go to work on that day. So whether we call it storytelling, whether we call it omissions, the bottom line is there is dishonesty in the statements made by Mr. White.
Thank you, Sheriff Hunter. Any other aggravating or mitigating factors by anyone?
I have one point of clarification. This is Marie Atwood for the record. When we were reading the previously noted aggravating factors, one of them that was discussed last time was that Mr. White had not notified DPSST of these issues. Today, however, during his verbal mitigation, he indicates that he did. So I want to make sure that the committee members are still wishing to adopt their previous aggravated factor of the belief that he did not notify, or if there's any discussion or change of that factor in particular.
Nick Hunter, for the record, I think that would be a clarification that would need to come from DPS S&T, because the way that Mr. White is sharing it is that he did do something. The question is whether what he did, was that procedurally correct within procedurally stated timelines. So I think that is a question for DPS ST to answer.
Okay. So that
I
may be a
can
question
provide
for you,
some
Jennifer, if you have a clarification.
The information that I have, having received this case after I came on, so there were other people involved, is that Mr. White did provide us information about the most current charge and conviction for reckless driving. There was a prior conviction, or not conviction, there was a prior criminal action that we did not have any information about. Therefore, we made that finding. So in one case, yes. In the prior case, no.
Nick Hunter, for the record, Jennifer, you're referring to the prior conviction that then was subsequently dismissed after the year of probation.
The failure to provide care.
Correct.
Yes.
So it was subsequently dismissed, but it was a conviction originally.
I would have to see whether we would internally call that through our rules a conviction or just a criminal disposition. I believe it's under Oregon Administrative Rule definitions a criminal disposition.
Okay.
Yeah.
Thank you for the clarity.
Yes, thank you, everybody. Any other comments? Information? Okay. You wanna go ahead and repeat the aggravating and mitigating
Sure.
factors for us?
I will just read them back from the minutes, if that's okay.
Yep.
And then the additional comments I will.
Perfect, thank you, Jennifer.
We do not have, in either today's case or when we heard the case last time, any mitigating factors. We do have aggravating factors. White's numerous traffic violations after his conviction shows a disregard for the law. White's mitigation letter did not include any responsibility for his actions. White blamed others. White has taken no accountability for his traffic law violations, which continued into 2024. White has exhibited a pattern of disregard for the laws of the state of Oregon and the state of Washington. Driving 102 miles per hour on a motorcycle is putting the public in significant jeopardy with disregard for human life. The arbitrator's opinion related to reinstating White's employment relied on procedural issues. The arbitrator affirmed that White engaged in misconduct. White's criminal conduct is aggravating. White did not report his criminal conduct to DPSST or ODOC appropriately, as we clarified today. White's failure to report the criminal conduct could be considered dishonest, but not a moral fitness violation as outlined in Oregon Administrative Rule. In addition to that, what I heard today was the verbal statement that he provided. There was a continuation of no accountability and blaming during that statement. That White's dishonesty in his statements in the investigation and in the arbitration were dishonest. One might call them stories or excuses or omissions, if I captured that correctly.
Okay, that's everything. So, everybody has a consensus that she identified them correctly?
Yes.
Okay. So we will now, open the discussion whether we're gonna affirm, modify, or negate, the staff report. So I believe now we need to have a motion for that.
So Nick Hunter for the record, and Kathy, you can help me here, or Marie, you can help me here, because what I would like to do is make a motion to amend the staff report to include dishonesty as well as the misconduct that is previously stated. And I would like to include dishonesty, as I stated in the aggravating factors. Even the arbitrator had an issue with Mr. White's storytelling. And so if you look at the progression of the entire case file that we read, we saw multiple explanations for his actions. And I do believe that those multiple explanations, we can say somewhere in the middle lies the truth. The problem is the truth was not stated from the beginning to the end, which would be a pattern then which would support the dishonesty as being included in the staff report.
So Marie Atwood, for the record, I think it procedurally might work too. So are you making one motion to affirm the existing allegations, another motion to modify by adding an additional allegation?
So moved.
Okay.
I will make that motion.
Okay.
Yes.
So the motion would be to affirm, and then modify.
Affirm on the misconduct and modify by including dishonesty.
Okay, thank you.
Ted Langley for the record, I had a second.
Thank you. So we go ahead and take a vote.
Right, we are voting on a motion to affirm the moral fitness violations presented and to modify to include dishonesty. Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bourne?
Aye.
Committee Member Bowden?
Aye.
Committee Member Fasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, so the next will be to decide what action or no action to be taken. So we'll call for a motion for what anybody recommends for
Ted
that.
Langley for the record, I make a motion that the board take action.
Margaret Boone for the record, I second.
Okay, we'll have a vote whether to take action in this case.
Right, we are voting on a motion to take action. Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Bourne?
Aye.
Committee Member Bowden?
Aye.
Committee Member Fasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, since the motion passed to take action, now we need to determine what that action may be. This is a dishonesty and a misconduct. For the dishonesty, it is potentially a lifetime ineligibility period. So if anybody has a motion for that.
Nick Hunter, for the record, I would make a motion for an ineligibility period of 5 years, based on the staff report identification of misconduct, the supporting statements that have been made today into the record supporting that misconduct, as well as the addition of dishonesty into the record as well, and the statements made supporting the dishonesty discovered throughout the case file. With all of that being entered into the record, I would suggest or make a motion for an eligibility period of 5 years.
Okay, thank you.
Josh Eldridge, I would second.
Okay, so the motion is to have an eligibility period of 5 years. We will take a vote on that.
Mike Hartford, for the record, just quickly, it appears last time we recommended, even without the dishonesty allegation that we recommended 10 years of ineligibility. So just putting it out there that previously we recommended 10 years, we're adding a dishonesty component to this, and the recommendation is now 5 years.
That's correct. So that is correct, and so then I think that either we have to vote on this, and then if it doesn't pass, then we can have another motion. I do believe that's correct. Correct? Okay.
Right, we are voting on a motion for a 5-year ineligibility period. Vice Chair Cameron.
Nay.
Committee Member Aldrich.
Nay.
Committee Member Bourne.
Nay.
Committee Member Bowden.
Nay.
Committee Member Fasco.
Nay.
Committee Member Frost.
Nay.
Committee Member Hartford.
Nay.
Committee Member Hunter.
Nay.
Committee Member Langley.
Nay.
Committee Member Mays.
Nay.
Committee Member Tabor.
Nay.
Motion failed.
Okay, so that motion failed. Is there any other motion to
Mark
present?
Bowden, for the record. What is our time frame for these? Like, I know dishonesty is up to lifetime, but I mean, I've seen lifetime for less here. I mean, we have a blatant disregard for all criminal activity. I mean, 8 violations in 8 years. Safety and security of the people that he's supposed to protect, and then dishonesty.
Right, so I'll repeat. So misuse of authority or misconduct is 3 to 10 years, and then dishonesty, misconduct that is discriminatory is 3 years to lifetime. So certainly you can make a motion.
Catherine,
What you
coming
think
for the
is
record, so the totality, because you have 2 different moral fitnesses, is 3 to lifetime is within your range.
Okay, thank you, I appreciate that.
Mike Hartford, for the record, I recommend a 10-year ineligibility period consistent with our previous recommendation.
John Frost, for the record, I'll second that.
Okay, we'll take a vote for a 10-year ineligibility period.
We are voting on a motion for a 10-year ineligibility period. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Nay.
Committee Member Fasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Nay.
Motion passed.
Okay, so motion passed for a 10-year ineligibility period for Mr. White.
I'm sure you can excuse Mr. White.
Mr. White, yes. You can certainly stay on. It's a public meeting, or you can choose to leave, and we thank you for your testimony. We will move next to, case number 5, Catherine Mood. Jennifer?
Jennifer Lavario for the record. This next case before you is that of Catherine Mood. The department opened a professional standards review after receiving information from Catherine Mood that she was criminally cited on March 23, 2022 for driving under the influence of intoxicants, reckless driving, failure to perform the duties of a driver, and criminal mischief in Marion County, Oregon. Ms. Mood's employer at the time, the Marion County Sheriff's Office, conducted an investigation into the March 23 incident and imposed an economic sanction that included Ms. Mood signing a last chance agreement for a 3-year period. The last chance agreement was signed on November 25th of 2022. On October 17th of 2023, Ms. Wood was cited a second time for driving under the influence of intoxicants and reckless driving in Marion County. On October 18 of 2023, Ms. Mood was placed on administrative leave by the Marion County Sheriff's Office and an investigation was initiated. On January 12th of 2024, Ms. Mood resigned from the Marion County Sheriff's Office pursuant to a separation agreement and release, rendering their internal investigation suspended. On October 1st of 2024, Ms. Mood pled guilty to the driving under the influence and reckless driving charges stemming from the October 17th incident. The department's review determined that Ms. Mood did violate the board's moral fitness standards for dishonesty and misconduct. Dishonesty. Ms. Mood was intentionally deceptive during her criminal investigation on March 23, 2022 by fleeing the scene of the crash she caused while driving under the influence of intoxicants. Ms. Wood attempted to hide behind a tree from law enforcement and denied more than once that she had been drinking. Ms. Mood's blood alcohol content for this incident was 0.24%. Ms. Mood was intentionally deceptive during the criminal investigation on October 17th of 2023 by stating she had not been drinking but had consumed cough medicine with codeine. Ms. Mood's blood alcohol content for this incident was 0.13%. Misconduct. Ms. Wood violated criminal law by committing 2 separate offenses of driving under the influence and reckless driving, and then a failure to perform the duties of a driver, property damage, criminal mischief as well, excuse me. Ms. Mood harmed property when she crashed into a PGE power pole, causing a power outage in Kaiser, including that of the Kaiser Police Department. The estimated damage in this crash was $30,000. Ms. Mood threatened harm to people and property for driving under the influence of intoxicants in both cases, which were within a year of each other. Ms. Mood harmed the efficient operations of the Kaiser Police Department when she hit the power pole, leading to a power outage at the police department. Ms. Mood harmed the efficient operations of the Kaiser Police Department when, during one of the criminal investigations, she removed her driver's license from a counter in the police department and placed it in her pocket. The arresting officer determined this had happened only after seeing Ms. Mood on video. On video surveillance. Ms. Mood's conduct impeded the arresting officer's ability to process her arrest efficiently. Ms. Mood harmed her employing agency by damaging the public's trust in the integrity of the police profession. Vice Chair Cameron.
Thank you. So we just needed.
Madam Chair,
I'm
before
sorry.
we get started, I just want to state for the record a conflict of interest. I am the one I accepted Ms. Mood's resignation as the sheriff. I don't know if that means I need to recuse myself from it. I just wanted to state the conflict of interest.
Kath McAlpin, no, you don't, just stating it, and if you feel that you can make an objective vote, then you're free to continue to vote. Just note the conflict is noted. Thank you.
So first we'll go into, if we have a consensus to adopt the record as stated by Jennifer. Is everybody good with that? Any discussion?
Oh, Vice Chair Cameron, I just want to correct something I said in my opening statement.
Yes, please do.
My last line was that she damaged the public's trust and integrity of the police profession. We're talking about the corrections profession here.
Okay.
Thank you.
Okay, yes, thank you. Also, I saw that member Langley has left. Do we still have a quorum?
We do.
Okay, very good. Confirm we are, have a consensus to adopt, the staff record. Now we will open it up for discussion, for any aggravating and mitigating factors, and just remember to state your name for the record.
Josh Aldridge, for the record. Aggravating circumstance is the multiple criminal arrests in a short period of time. Additional aggravating circumstance is that during both of those incidents, Ms. Mood was deceptive and evasive during the arrest proceedings.
Thank you.
Mary Bowden, for the record. Another aggravating factor was that she actually fled the scene of her accident and tried to hide it from the police.
Thank you.
Lori Frosco, for the record. Aggravating factor is dishonesty at the time of offense and no accountability for her actions.
Thank you. Jennifer Cameron, for the record, one thing that stood out was she was given a chance to make things right, and she did not. So I find that as an aggravating factor. Any other discussion? Anyone online have anything?
Josh Aldridge, for the record. Sorry.
Nope, you're good.
I believe the second offense was while Ms. Mood was on diversion for the first offense.
Mm-hmm.
And so I believe that's an aggravating factor. Additionally, one more piece is surrounds her interfering with the investigation by taking her identification while the arresting officer was trying to process that arrest, another aggravating factor.
Thank you. Any other aggravating or mitigating factors by anyone? Okay, if we can repeat those.
Thank you. Jennifer Lavario, for the record. I heard no mitigating factors from the committee. The aggravating factors were that there were multiple arrests in a short period of time. During both, she was deceptive and evasive, and I heard dishonest as well. She fled the scene of the accident. She took no accountability for her actions. Even after being given a chance, she did not, she went ahead and did, let me restate that. After being given a chance, she didn't take that chance. Her second offense was while she was on diversion, and by interfering with the arrest, and by taking the ID off the counter, that impeded the investigation.
Okay.
Nick Hunter, for the record, I would add an aggravating factor of a pattern of dishonesty from the first arrest through the processing, the intentional dishonesty of taking the ID off the counter, and then the continued dishonesty with the second arrest.
Okay, thank you. Do we have a consensus that those factors were as stated by everybody? Okay. Yep, okay, let's move on. Now we can affirm, modify, or negate the staff report. So we can call for a motion on that.
Josh Aldridge, for the record. I would move we affirm the staff report showing violations of misconduct and dishonesty.
Mike Hartford, second.
Okay, so we have a motion to affirm the staff report as recommended for misconduct and dishonesty. And I think, yep, that's it.
All right. We are voting on a motion to affirm the moral fitness violations as presented. Vice Chair Cameron.
Aye.
Committee Member Aldridge.
Aye.
Committee Member Boren.
Aye.
Committee Member Bowden.
Aye.
Committee Member Frasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. Now we need to have a motion whether we're going to take action or no action.
Margaret Bowden, for the record. I motion we take action.
Thank you.
Lori Frosco, second.
There's a motion to take action in this case.
We are voting on a motion to take action. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden. Committee Member Pasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, since we have a motion to take actions past, the next step we need to take is have a motion for the recommendation of an ineligibility period. Since there is dishonesty and misconduct, it's 3 years to lifetime. And when you make your motion, please specify your reasons why and the timeline you're recommending.
My card for the record. I'm recommending a lifetime ineligibility period, pattern of dishonesty. She can't be trusted in law enforcement going forward, I believe. And the ongoing unaddressed alcohol issues make her unfit to be a officer in order.
Thank you.
Josh Aldrich for the record, I'll second.
Okay, so we have a motion for a lifetime ineligibility, I don't know why I have a hard time with that word, ineligibility period. So can we have a vote?
Yes, we are voting on a motion for a lifetime ineligibility period. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Bosco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, we'll move on to agenda item number 6, which is Chance Oxman. And I think Jennifer's presenting that to us as well.
Thank you, Vice Chair Cameron. Jennifer Lavario for the record. The next case before you is that of Chance Oxnam. The department opened a professional standards review after receiving information that Chance Oxnam was cited for driving under the influence and transporting a minor while under the influence on August 18 of 2023 in Meridian, Idaho. On October 3rd of 2023, Mr. Oxnam entered into a diversion agreement for the DUI and the transporting a minor while under the influence charge was dismissed. On October 17th of 2024, the DUI was dismissed due to Mr. Oxnam's successful completion of the conditions of his diversion program. Mr. Oxnam is currently employed with the Department of Corrections, Snake River Correctional Institution. The department's review determined Mr. Oxnam did violate the board's moral fitness standards for misconduct. Mr. Oxnam violated criminal law when he was cited and charged with DUI and transporting a minor while under the influence in Idaho. Mr. Oxnam threatened to harm his minor son, an adult passenger, and other people and property when he drove his vehicle under the influence of alcohol and over the legal limit. Vice Chair Cameron.
Thank you, Jennifer. So we need is there a consensus of the committee to adopt the record, the staff record as presented by Jennifer? It looks like I have a lot of thumbs up. So we have adopted the record through consensus. Next we'll open for discussion for the aggravating and mitigating factors.
Josh Aldrich for the record, aggravating factors. First, that other individuals, including minor children, were placed at risk because of this decision to drive while under the influence. And then second aggravating factor is that at the time of the arrest, at least, Mr. Oxnam was not forthright about his drinking that day.
Is that it?
That's it for now.
Thanks.
Nick Hunter.
John. John Tabor, for the record. Mitigating factor, he completed his diversion program as required.
Thank you.
Nick Hunter, for the record, mitigating factor. Mr. Oxum did provide a mitigation letter where he appears to have taken accountability for the action, also highlighting that he does not have any internal disciplinary measures or anything else that's ever been taken against him.
Thank you. Anything else? Online? Okay. Can we repeat those factors, please?
Yes, thank you, Chair. Jennifer Lavario, for the record. I have in this case for mitigating that Mr. Oxnam completed his diversion. He provided in his mitigation letter some accountability for his actions, and that there are no other known disciplinary actions in his career with the DOC. Aggravating, other people, including a minor, were put in harm's way that day when he drove under the influence. And that at the beginning of the arrest, he was not forthright with the officer about his drinking.
Thank you, Jennifer. Then we just need to make sure there's a consensus regarding the identified factors that Jennifer has presented. Anybody online have any comments? Okay. So there's a consensus regarding the mitigating and aggravating factors. So the next, we need to call for a motion to either affirm, modify, or negate the staff report as indicated.
Nick Hunter, for the record, I'll make the motion that we accept the staff report as prepared.
Thank you.
Mark Boren, I'll second.
Okay, we have a motion to accept the staff report as prepared.
We are voting on a motion to affirm the moral fitness violations as presented. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Frasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. The next motion will need to determine if we want to take action or no action. So I'll open it.
Josh Aldrich, for the record, I would move that the committee recommend to take no action, and I would base that on the fact that he's taken accountability for his actions, he's completed diversion, and this is just an opportunity to give him an opportunity.
Thank you.
Nick Hunter, for the record, I'll second that.
Thank you. So there is a motion to take no action in the case of Chance Oxnam. Can we have a vote, please?
We are voting on a motion to take no action. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Frasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. Next we'll move on to the case of Brian, I don't want to butcher the names, Sharbach. Sharbach, thank you. I appreciate that.
I did work with this person. Lori Frosco, for the record, I did work with this person during his employment. I did some training with him, and I wasn't involved in any part of doing this.
Okay, thank you for letting us know. Once again, Jennifer, you are up.
Thank you, Vice Chair Cameron. Jennifer Lavario, for the record. The next case before you is that of Brian Sharbach. The department opened a professional standards review after receiving information that Brian Sharbach had resigned from the Department of Corrections while under investigation into allegations of misconduct related to Mr. Scharbach's accessing confidential information about another Department of Corrections staff member and then sharing it with others without consent. The department's review determined that Mr. Scharbach did violate the board's moral fitness standards for misuse of authority and misconduct. Misuse of authority, Mr. Scharbach intentionally misused his authority when he used it to access the confidential officer in charge field training evaluation program files of a fellow officer without their or DOC's permission. This access was for Mr. Scharbach's personal gain and did not have any business purpose. Mr. Scharbach intentionally misused his authority to place a personal thumb drive with admittedly pirated movies on a DOC computer in order to view these movies while on duty for personal gain and entertainment. Under misconduct, Mr. Scharbach admittedly used his access to confidential information to harm a fellow officer's reputation by exposing negative information about them to other officers. This conduct did threaten harm to the fellow officer's reputation. Mr. Scharbach's conduct harmed the safety and security of the DOC's Department of Corrections confidential information systems when he accessed unauthorized information and by downloading content from a personal thumb drive, exposing the Department of Corrections to potential corruption of files and threatening the efficient operations of the agency. The totality of his conduct also harmed the integrity of the Department of Corrections information systems and violated the Law Enforcement Code of Ethics. Mr. Scharbach threatened physical harm to staff who he believed turned him in for this conduct. He did so in a phone conversation with the officer in charge. Chair Cameron.
Thank you. So do we have a consensus to adopt the record, the staff record as stated, or return for any information? Everybody, okay, we're in consensus to adopt the staff record. Now we can open it up for discussion on aggravating or mitigating factors regarding this case.
Ted Langley for the record. One aggravating factor that I found was the downloading of the movies onto a thumb drive. Whether or not he got charged with a crime, that's theft. It was copyrighted material. The other aggravating factor I wanted to point out was the threat to harm another staff member isn't just a threat. That's him voicing that he'd be willing to commit yet another crime of assault for. So I found both of those to be aggravating factors in the case.
Thank you.
John Tabor for the record. An aggravating factor is the amount of information provided to staff regarding the confidentiality of our electronic information is far and away enough for him to have understood that what he did was outside the bounds of our own rules and policies.
Thank you.
Nick Hunter for the record, aggravating factor. He was well aware of that and made the statement out of his own mouth that he admitted to not following the code of ethics. Another aggravating factor, using his own statements. I mean, I'm not an OIC, so no, when asked if you're supposed to be referencing or going into these files. A blatant disregard for policies and procedures, as stated in his own words throughout the internal investigation, which is bordering on being sociopathic, amongst other things.
Thank you. Jennifer Cameron for the record. An aggravating factor for me, and I'm kind of going off what Member Langley stated, the threats to the others who he thought had kind of narked on him. Not to mention it's potential threatening to commit assault, but just the intimidation and kind of in some ways attempting to interfere with the investigation or threaten people so that maybe they don't give the correct information or whatever. I just find that not okay either.
Part of moving for the record, aggravating factor also to go off Ms. Lightly as well. With the jump drive or the thumb drive, he admits to taking it to work. He also admits to watching movies while he's at work, which could be considered theft of time and not doing what he's supposed to be doing, which is watching the inmates, I would assume. So,
Nick Hunter for the record, aggravating factor, and it goes along with where Captain Langley was at, but I think had this been sent out, there's also, I'm not sure you get to official misconduct 1, but I think you could have done an official misconduct 2 based on the information that he was disseminating and how he was accessing and disseminating that information. So I think, along with Captain Langley, there are multiple criminal charges that exist in the midst of this investigation.
Thank you. Anything else from the members? Okay. Want to repeat all that?
Vice Chair Cameron, that's Jennifer Lavario for the record. I did not hear any mitigating factors from the committee. The aggravating factors that I identified through your discussion are that Mr. Scharbach downloaded movies, which he admittedly pirated, which is theft. His threat to harm of those who were turning him in wasn't just a threat, but potentially an admission of another crime, potentially assault. The amount of information provided to staff about confidentiality at the Department of Corrections was clearly enough for Mr. Scharbach to know that he was breaking the rules. Mr. Scharbach was well aware and admitted to not following the Code of Ethics. There was a blatant disregard for the policies and procedures of the department in his own words. His threats to others were intimidating and potentially interfering with the internal investigation. He admitted to taking the thumb drive and not only watching movies while on duty, but placing the thumb drive in the DOC computer, which could be considered a theft of time. The totality of the things that Mr. Scharbach, the conduct here in Mr. Scharbach's case, could have led to an official misconduct charge. And I believe that's all I have.
Thank you.
Nick Hunter for the record, on an aggravating factor, I'm reviewing and I'm looking at the staff report, and the staff report not addressing dishonesty. I think dishonesty is a factor that should be considered in this. Although when he first discovered the file, he sent something to, and you guys can correct me on the proper term, but the assistant security or something of security. He sent it to somebody to say, hey, I got access to this file with screenshots, but then he proceeded to just share that information and use that information, which has dishonesty built into that. It is omission. He is omitting the fact that he is calling on these other people, showing this information and doing those things, which he should know to be wrong based on that code of ethics. So I would add that as an aggravating factor, and we can address that in the staff report.
Thank you.
Ted Langley for the record, I did want to clarify one thing. When I brought up the threat on the staff and potentially him showing willingness to commit another crime, if I misspoke and said he was confessing or admitting to committing the crime, that's not what I intended. I was just intending to say that he showed willingness to do that, that's all.
Thank you for clarifying. Okay, is there consensus to the aggravating factors as indicated? Yes. Any objections online or not seeing any? Next, we will call for a motion to either affirm, modify, or negate the options of the moral fitness findings identified in the staff report. Is that correct? Yes. It is right. I know, I'm getting through this, what can I say?
Nick Hunter for the
I'm
record.
not perfect.
I would make a motion this time that we modify the findings in the staff report accepting the findings of misconduct and additionally adding dishonesty based on what was just identified in the aggravating factors of knowing what he was doing and omitting all of that is a form of dishonesty that I think is supported by what is contained in the case file.
Thank you. I don't know if I could repeat that.
You're not the first one to say that to me, it's okay.
Josh Eldridge, I would second that motion.
As stated.
Yes.
As stated, exactly, sure.
Marie, I would one point of clarification. So in the motion as it stands, it was a motion to accept the allegations of misconduct and to add a finding of dishonesty, but there was also a finding by our staff for misuse of authority. So what, if anything, would the committee like to do with that?
I would amend my motion and add misuse of authority as accepting that before modifying to add dishonesty.
Motion to amend the motion to modify.
Yeah, I'm gonna make a
and
motion
accept.
to amend my motion, accepting the original findings in the staff report of misconduct and misuse of authority, and then for the reasons stipulated and stated, to add dishonesty.
Thank you.
Josh Eldridge, I would second the amended motion by Sheriff Hunter.
Okay, so I appreciate you making it difficult for me. So I'm just gonna throw out there, what we have on the table then is to accept the staff report as written and then modify to add the dishonesty element. That's simple.
Correct.
Okay, go for it.
We are voting on a motion to affirm the moral fitness violations presented and also to modify to include dishonesty. Vice Chair Cameron?
Aye.
Committee Member Aldridge?
Aye.
Committee Member Bourne?
Aye.
Committee Member Bowden?
Aye.
Committee Member Fasco?
Aye.
Committee Member Frost?
Aye.
Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Thank you. The next step will be to determine if we plan to take action or no action in this case. Jennifer Cameron, for the record, I recommend we take action.
Margo Boyd, for the record, I second.
Thank you. So the motion to take action in this case.
Right, we are voting on a motion to take action. Vice Chair Cameron?
Aye.
Committee Member Aldridge?
Aye.
Committee Member Bourne?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, so there is, the motion passed to take action, so our next step will to determine what action that might be and what eligibility period we'll recommend it. Since we added dishonesty, we have dishonesty, misuse of authority, and misconduct, it would be anywhere from 3 years to a lifetime.
For the record, I'll make a motion to support lifetime ineligibility. You have dishonesty, misuse of authority, and misconduct. That misconduct has stated and discussed potentially could have been criminally investigated and potentially could have been criminally charged. But I think there is a pattern of behavior here that is way outside the ethical bounds of what we expect of our public safety professionals here in the state of Oregon.
Thank you.
Mike Hartford, for the record, second.
Okay. So we have a motion for a lifetime ineligibility period based on dishonesty, misuse of authority, and misconduct. Go ahead.
We are voting on a motion for lifetime ineligibility period. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Frasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, does anybody need a break or anything? Just checking, we've been here a little while, just thought I'd throw that out there. I don't know if we're-
12:45.
About an hour, 15 minutes.
Yeah, oh yes, because that's right, she has.
Yeah, but if
she have to go,
people
but
need a
if,
break,
I mean, it's 11:30 and I figured we have 2 cases plus a little bit more if we've been here for an hour and a half. So if anybody needs something really quick, or hopefully we can get through quickly, you good? Okay, so we'll move forward. Just throwing that out there. I like to respect people.
We've had a
you know.
Well, you need
couple of
5.
online requests for a break to take 5.
Request take 5, just throwing that out there in case anybody needs it, so. They may need 5, we're good. We're
Yes.
moving forward? Okay.
Take 5.
Hang tight for 5 minutes, thank you. Sorry, I just felt like people just needed to number 9, Kyle Stott. And Jennifer, if you wanna let us know about that case.
Sure, thank you, Vice Chair Cameron. Jennifer Laborio for the record. The next case in front of you is that of Kyle Stott. The department opened a professional standards review after receiving information that Kyle Stott, a probation officer, had resigned from the Deschutes County Department of Community Justice during a personnel investigation related to Stott engaging in a personal relationship with an adult on supervision, which he attempted to conceal. The department's review determined Mr. Stott violated the board's moral fitness standards for dishonesty, misuse of authority, and misconduct. Under dishonesty, Mr. Stott engaged in intentional dishonesty when he concealed his personal romantic relationship with an adult on supervision, a violation of agency policy. For misuse of authority, Mr. Stott intentionally misused his authority when he utilized his position of authority as probation officer over an adult on supervision's emotions and other life domains to initiate a personal, intimate relationship with her for his benefit. Misconduct. Mr. Stott engaged in misconduct when he entered into a personal, intimate relationship with an adult on supervision, concealed it from his employer, and misused his authority to do so. His conduct brought harm to his agency by giving the appearance of a conflict with his work and exposing his agency to legal action. Mr. Stott's conduct threatened harm to the community when he engaged in a personal relationship with an adult on supervision, which eroded the community's trust that probation officers are fair, honest, ethical, and professional in their conduct. Vice Chair Cameron.
Thank you. Is there a consensus to adopt the record as stated? Thank you. We'll move forward then to discuss any aggravating or mitigating factors in this case.
Ted Langley for the record. The moral fitness violations that are listed in this case, one of the things that struck me is every single one of them does something to erode public trust. And I believe that without public trust, our job is impossible to do. And that was probably the thing that struck me the strongest in this case, was just the fact that every single one of these hurts our position with the public.
Thank you. Jennifer Cameron for the record. Aggravating factors. The lack of boundary setting. This is something that never should have even crossed this individual's mind. It creates, as Captain Langley stated, mistrust for the agency. Not to mention, I'm kind of confused at why criminal charges weren't brought up, but that may not fall in this case. I know for other people it has been. It creates, I think, safety issues within the agency when employees are having personal relationships with people on supervision because of associates and those kinds of things. And then the dishonesty. So just the lack of boundary setting was disturbing to me.
Mike Hartford for the record. When officers engage in relationships like this, even if the person on supervision or adult in custody is claiming to be going along with this relationship, the power dynamic is such that they're unable to consent to a relationship like this, and they're a victim in this case.
Is that an aggravating factor?
Yes, aggravating.
Thank you. Anything else from anyone online?
Nick Hunter for the record. I think the aggravating factor that I have, and it kind of just goes with the same thing, Jennifer, that you're talking about with whether this is official misconduct and that piece, is that at no point in this case file did he intend to share this information with anyone. He was literally sort of juggling the balls in the air right until a judge made a decision that he didn't expect that judge to make. And that's the only reason that this all started to come to light. So the very, very intentional dishonesty referred to again by Commander Hartford, and the distrust that created within his own agency, putting other people in jeopardy when the probationer was the one that says, hey, I can't be assigned to a certain PO. That's really concerning with the information that probationer knows about the internal system that probationer should probably have no idea of whatsoever. So, although not specifically covered in the record, I'm sorry, Jennifer, I just keep going and you're dying here. Yeah, I have a very, very big issue with the dishonesty and potentially the oversharing that he had by establishing this personal relationship.
Thank you. Anything else? Okay, Jennifer, if you want to let us recall, let us know it.
Yes, thank you. Jennifer Lavario for the record. I did not hear any mitigating factors from the committee. The aggravating factors I recorded are that each of the moral fitness violations that the department identified erode public trust. There's a theme of erosion of public trust in them, and that law enforcement agencies and officers cannot do their job if there is an erosion of trust. The lack of boundary setting creates mistrust within the agency because of the associations that adults in custody have and other factors. When officers engage in these relationships, the power dynamic creates the inability for the adult in custody to consent to these types of power dynamics. And at no point did Mr. Stott intend to share this information until a decision by a judge in his case. The dishonesty was very intentional, and I'm going to try and paraphrase Mr. Hunter's information, if I heard you correctly, that by a probationer bringing up that they probably should be with someone else, that's very telling in terms of how wrong this situation was.
I like that summary.
Okay, good. Thank you.
I just want to note too, one of the words that you used was adult in custody. This
thank
wasn't an adult in custody, it was
Correct.
adult on supervision, so I
Thank
just
you.
want to clarify that
Appreciate that.
for the record. So do we have a consensus that the aggravating factors and they're good? Okay. The next, we need to have a motion to affirm the moral fitness violations, modify them, or negate them. Is that correct? Yes.
Nick Hunter for the record. I would make a motion that we affirm the moral fitness violations as identified in the staff report, all three of them being dishonesty, misuse of authority, and misconduct.
And Jennifer Cameron, I'll second that. So we have a motion to affirm the moral fitness violations as presented in the staff memo.
We are voting on a motion to affirm the moral fitness violations as presented. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Boren.
Aye.
Committee Member Frasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, moving on. Our next step is to determine if we plan to take action or no action against Kyle Stott.
Josh Aldridge for the record, I recommend we take action.
Mark Bourne, for the record, second.
Okay, we have a motion to take action in the case on Kyle Stott.
We are voting on a motion to take action. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Vasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter. Aye. Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, so the next, we'll need to determine the action we're going to take in the ineligibility period. Since this is dishonesty, misuse of authority, and misconduct, it is 3 years to a lifetime ineligibility period. When you make your recommendation, please state why.
Ted Langley for the record. I'm recommending lifetime ineligibility because of the intentional dishonesty, and even though I don't need anything other than that, I'm gonna say also because of the public trust issue that I brought up, the potential danger to his fellow employees that was brought up by Vice Chair, and also because his actions ultimately victimized somebody that he was supposed to have care over.
Thank you.
Mike Hartford, a second.
Thank you. Okay, so we have a motion to have a lifetime ineligibility. So let's go.
We are voting on a motion for a lifetime ineligibility period. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Vasco. Committee Member Frost.
Aye.
Committee Member Hartford.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay. So our last case is agenda item 10, Timothy Trabosh.
Mike Hartford, for the record, Vice Chair. I was the investigator in all of these investigations. I believe I have to recuse myself from this one.
Thank you.
And Nick Hunter, for the record, is a Marion County employee who I'm very familiar with in this investigation, although I did not participate in this investigation at all.
Thank you for letting us know. Jennifer?
Thank you, Vice Chair Cameron. Jennifer Lavari for the record. The final case before you today is that of Timothy Trabosh. The department opened a professional standards review after receiving information that Timothy Trabosh, probation officer, resigned from the Marion County Sheriff's Office Community Corrections Department on December 2, 2022, while under investigation for 2 open personnel investigations related to loss of work property and multiple policy violations, including code of ethics, standards of conduct, sexual misconduct involving offenders, and discrimination and harassment-free workplace. The department's review determined Mr. Trabosh did violate the board's moral fitness standards for misuse of authority and misconduct. Misuse of authority, Mr. Trabosh intentionally misused his authority when he made an inappropriate and sexually suggestive comment about his coworker to a client who was on supervision. The client could not consent to such conduct, thus Mr. Trabosh placed him in harm's way as a byproduct of being subjected to Mr. Trabosh's comments while under conditions of supervision, including Mr. Trabosh's ability to make decisions about that client's liberty. Misconduct. Mr. Trabosh harmed his coworkers by making an inappropriate and sexually suggestive comment to a client on supervision that was overheard and made coworkers feel uncomfortable and fearful that they may be subjected to a Prison Rape Elimination Act or PREA investigation. Mr. Trabosh harmed the client on supervision by placing them in a position they could not consent to, which involved an inappropriate and sexually suggestive comment in a joking manner giving the client little to no other choice but to go along with the joke. Mr. Travish harmed the efficient operations of the Marion County Sheriff's Office Community Corrections Department by engaging in conduct that damaged the right to a discrimination and harassment-free workplace, the oath of office, and the code of ethics. Vice Chair Cameron.
Thank you. So, do we have will we still have a quorum if Mr. Hartford's not?
Yes.
Okay. Not that we're there yet, but the consensus to adopt the record, as stated, by Jennifer. Do we have a consensus? Okay. Moving on, we will open the case up for discussion. Just remember to state your name and identify any aggravating or mitigating factors.
Nick Hunter, for the record. Aggravating factor, the repeated and patterned behavior of discrimination and harassment in the workplace based on the multitude of comments that Deputy Trebosh made to his peers, employees, everyone he came into contact with.
Thank you.
Josh Aldridge, for the record. Aggravating factor is that some of those comments were also made in front of adults on supervision, kind of bringing them without their consent into the conversation.
Thank you.
Ted Langley, for the record. I found it aggravating that someone with almost 22 years of service, and I went through his training record and totaled up 139 hours of training that he completed. It had something to do with ethics, leadership, anti-harassment, and other subjects that I just feel there's no way he could not have known that his behavior was inappropriate, and he should have expected that he'd be in trouble for it.
Thank you.
Josh Aldridge, for the record. Aggravating circumstance, even in situations where he was told to stop making further comments, he continued to do so, and essentially so. I think there's a quote where he said, in one case, tell your husband to get over it, showing that he had no intention of stopping that behavior.
Thank you.
Dick Hunter, for the record. Aggravating factor, not specifically stated in these reports, but to go off of Aldridge's comment, that was also another member of law enforcement, happened to be his spouse. So this was damaging to not only Marion County and the public, but this was also damaging to other law enforcement agencies that Marion County interacts with. And as we all know, community corrections is someone that engages with all of our law enforcement partners.
Thank you.
Ted Langley, for the record. Also, there was a meeting that he was asked to attend on December 1st in 2022 with an investigator, which he refused to go to, and I felt like his unwillingness to cooperate was also aggravating.
Thank you.
Josh Aldridge, another aggravating factor. While not the primary focus of this report, there are references to other policies that Mr. Trebosh chose to just disregard surrounding MCSO property and his lack of interest in securing that property appropriately, which resulted in loss to the sheriff's office.
Thank you.
And Nick Hunter, for the record, aggravating, again, what Lieutenant Aldridge just said, there's a pattern of disregard for all sheriff's office in Marion County policies, not just discrimination, harassment, not just property. These are a pattern that he is just disregarding policies in general.
Thank you. Anybody not seeing any hands up online at all? Okay. Jennifer, you want to repeat those for us?
Thank you, Vice Chair Cameron. Jennifer Barrio, for the record. I did not hear any mitigating factors from the committee. The aggravating factors I identified were that this behavior was repeated in the areas of discrimination and harassment, and based on several comments that Mr. Travish had with his coworkers. Some comments were made in front of adults on supervision. Mr. Travish, having 22 years of experience and 139 hours of training, some of which is in ethics and leadership, etc., there's no way he could not have known this was the wrong behavior. Even when told to stop, he continued to do so. I think how I'm going to paraphrase Mr. Hunter's comment that wasn't in the record is that this conduct damaged other law enforcement officers. And then there was reference to other policy violations in the record regarding Marion County Sheriff's Office property loss. And there was a pattern of disregard for all of the Marion County Sheriff's Office policies in general. The fact that Mr. Travish was provided the December 1st meeting date and refused to go shows his lack of cooperation in the matter.
Thank you. Any discussions with what Jennifer said? Is she right on? We have a consensus that she got everything as stated? I'm seeing heads nodding online. Okay. So we will decide if we plan to make a motion to affirm, modify, or negate the staff report regarding the moral fitness findings as identified.
Josh Aldrich, for the record, I move to affirm the staff report showing fitness violations of misuse of authority and misconduct.
Mark Ward, for the record, I'll second.
Okay, we have a motion to affirm and accept the staff report regarding the fitness findings as identified.
We are voting on a motion to affirm the moral fitness violations as presented. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Frasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hartford. Oh, sorry, you're abstaining. Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
So we'll move into whether we determine to take action or no action in this case, if there's a motion. Jennifer Cameron, for the record, I recommend we take action, or have a motion that we take action.
Nick Hunter, I'll second that motion.
Okay, there's a motion to take action in the case of Timothy Trabosh.
We are voting on a motion to take action. Vice Chair Cameron.
Aye.
Committee Member Aldrich.
Aye.
Committee Member Bourne.
Aye.
Committee Member Bowden.
Aye.
Committee Member Frasco.
Aye.
Committee Member Frost.
Aye.
Committee Member Hunter.
Aye.
Committee Member Langley.
Aye.
Committee Member Mays.
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, so our next decision is to determine the length of ineligibility period. We're dealing with misuse of authority and misconduct, so that is potentially an ineligibility period of 3 to 10 years. Oh, there wasn't
misuse of authority, right?
Dishonesty.
3 to 10.
Oh,
3 to, yeah. It's okay, it's why we had a break a little bit ago. Apparently you know that.
Nick Hunter, for the record, I'll make a motion to recommend a 10-year ineligibility period based on sort of the gross disregard when you look at his misuse of authority and then his identified misconduct, especially involving for 602 for us, but sexual harassment and other repeated comments and a pattern of behavior with just years of knowing he shouldn't, yet years of doing.
Josh Aldridge for the record, I'll second that for all the reasons the Sheriff Hunter stated.
Okay, we have a motion to recommend a 10-year ineligibility period regarding Mr. Trabosh.
Right, we are voting on a motion for a 10-year ineligibility period. Vice Chair Cameron?
Aye.
Committee Member Aldridge?
Aye.
Committee Member Bourne?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Tabor?
Aye.
Motion passed.
Okay, thank you. So next on the agenda is number 12, Corrections Policy Committee Chair and Applicant Review Committee nominations. Go ahead, Marie.
Thank you very much, Marie Allen, for the record. We have a couple orders of business today. The first being we need a chair for this committee. I would like to thank Vice Chair Cameron for her diligent efforts during this very long docket today. Well done. And at this point, I would kind of open the table to anyone who would like to make a nomination.
Well, I will make a nomination. I nominate Sheriff Hunter to be the CPC chair.
I would second that nomination.
Move to close nominations.
All right. Any questions, comments from online? Okay. All right. We are voting on a motion to nominate Nick Hunter as the chair of the Corrections Policy Committee. Vice Chair Cameron?
Aye.
Committee Member Aldridge?
Aye.
Committee Member Bourne?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Tabor?
Aye.
Motion passed.
Fantastic.
Second order of business on nominations is we need sort of follow-up nomination for the applicant review committee. So this kind of relates back to Member Boren's term on CPC is coming to an end. This will be his last meeting. The reason why he's currently on ARC is because of his membership in CPC. I think we would all love to see him continue on ARC, but you have to be re-nominated and re-voted on to that particular committee before we can make it official.
So he has to be nominated to be on the ARC?
Yes.
Okay. Well, Jennifer Cameron, for the record, I will nominate and Mr. Boren to be on the ARC committee.
Thank you so much.
Nick Hunter, I'll second that, and then, as Mark did, I would close all nominations.
Thank you. All right, we are voting on a motion to nominate Mark Boren to the applicant review committees. Vice Chair Cameron?
Aye.
Committee Member Aldridge?
Aye.
Committee Member Boren?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Tabor?
Aye.
Passed.
So just to clarify, I would be representing that as a public member on that and not representing any other committee.
You still represent corrections.
Yes, so the corrections profession, but not the CPC committee.
Oh.
Yeah, so a very slight
Just curious.
change, yeah.
Not that I don't want to, just curious how it works.
It's good to know. Okay, next, item number 13, which is the proposed rule changes for Oregon Administrative Rule 259-006-0010, presented by Jennifer. How, I don't know that, did they spell it right? I don't know that I ever noticed how it was spelled. Yeah.
That's correct.
Okay.
All right, thank you, Jennifer Howell for the record. Chair Hunter, Vice Chair Cameron, members of the committee. OAR 259-006-0010 was adopted in 2020 to establish the Applicant Review Committee. The rule outlines the purpose and membership of the committee, which is more commonly known by its abbreviation, ARC or ARC. The Applicant Review Committee was specifically designed to review professional standards cases for individuals who have just been hired but have criminal dispositions that occurred before they were employed in public safety. The committee generally meets on a monthly basis. Through this rule and Oregon Administrative Rule 259-008-0290, the board delegated the authority to deny training and certification for these specific cases to the Applicant Review Committee. This means that the committee's vote to take no action or to take action to deny does not require subsequent approval by the board. This delegated authority and the meeting frequency ensures that cases are reviewed in a timely manner and that the new hire can proceed with their basic training without significant delays once they've made it through the process. Since 2023, DPSST has been facilitating a work group to review our current moral fitness standards and processes. This included discussion related to the Applicant Review Committee membership and the appointment criteria. After reviewing the current membership requirements, the work group recommended 3 changes related to the Applicant Review Committee meeting member criteria. So when you look to the rule language in your memo on page 2, in section 2, the first recommendation was to change the board member position from a public member to any board member. Changing the designation from public member to any member would not preclude a public member from the board or the policy committee from being nominated and appointed to the Applicant Review Committee. In fact, since the Applicant Review Committee was established, several policy committee member representatives have been public members appointed to the ARC committee. In section 3, the second recommendation was to delete subsection B, which is shown as strike through, and that removes the prior policy committee experience requirement. While this requirement was initially intended to ensure that ARC members had experience reviewing professional standards cases and familiarity with committee processes, the requirement has proven to be more restrictive than necessary. In section 3, the third recommendation was to delete subsection E, again shown with strike through, to remove the language regarding the option to vacate a policy committee or member position. At the time the rule was adopted, it was meant to recognize that members may find that being on the policy committee as well as the Applicant Review Committee could take more time than they were able to provide, and not be able to do both. But no one has exercised this option, and it's been determined to be confusing and unnecessary. You'll also see some revisions in section 3A and the renumbered B. These include amendments that help clarify the nomination and appointment process to support implementation of the recommended changes. DPSST shared these rule changes with the Applicant Review Committee and the Moral Fitness Work Group in November and December of 2024. Neither of those groups identified any additional changes or concerns, and they supported moving forward with the rule changes. Timing-wise, the rule is coming for you today and not earlier because we paused all of our work group activities during the legislative session. So now we're picking back up to get back on track with that. We did present these rule changes to the Telecommunications Policy Committee last week. Their discussion included recognition that removing the requirement that the board representative be a public member could result in a period of time in which there isn't any public representation on the Applicant Review Committee. Just for some reason, one committee or another doesn't use a public member, and that would just be, that was just recognized for the record and for the implementation of the rules. But I will add to that in this meeting that as written, the rule change also would allow for any board member to become an Applicant Review Committee member. The board includes representation not just from criminal justice, but also from our fire disciplines and our private security disciplines. So I wanted to make sure, I wanted to find out if there would be any questions or concerns with leaving it the broad language of any board member, or if it needed to be narrowed to our criminal justice representatives on the board for the committee's discussion.
Ted Lanning for the record. And I would say, I think it's fine that it's every board member, but I saw something that, just because we reaffirmed Mr. Boren's place on the Corrections Policy Committee, yet he's not going to continue serving on the let me rephrase that. We just reaffirmed Mr. Boren's participation in the applicant review committee, yet he's not gonna be part of CPC. But what I'm reading on page 2, it says that there's gonna be 2 representatives from the Corrections Policy Committee on ARC. So if he's not a member of CPC, how does he move into the position on ARC? Because I don't see a method or an avenue for him to serve on ARC by this outline if he's not on one of the policy committees.
Thank you, Jennifer Howell for the record. I know that this was discussion that the initial work group back in 2020 when this was formed, looked at and discussed. And they were comfortable with a person who is currently serving, if their term ends on the committee that they're representing, continuing to, so let's say, because each applicant review committee term is a year, and a person has been appointed or reappointed, that even though their committee position ended in this time because they had remaining time left on their appointment, they were comfortable with the person continuing to serve their applicant review committee. And that was noted in part at that time with that statement that's actually in strike through here, not required to serve both committees.
So Nick, kind of for the record, does it clean it up then if we say that it's 2 representatives from the past or current members of Correction Policy Committee? Because then it would work cleaner that way?
Sure, and I would say it's probably a split here. Today, Member Bourne is a current member of the Corrections Policy Committee.
I see him over there.
Yeah, and so being appointed while currently a member, which is one of the requirements, and then allowing to finish out the term on the applicant review committee.
So Ted Lanning for the record, I totally understand your explanation, but maybe it would just require an addition of, in the applicant review committee rule, to just say, if a member, if their term on a committee resolves, but they are still a member of ARC, then they can continue that membership on ARC. Because I think if that was in there, then it would be clarified, because the way it looks right now, at least to me, the way it looks to me is like, if you're not on a committee, then you can't serve on ARC.
And Jennifer Cameron, when is your CPC?
October 28th.
Okay, so you're still on this committee?
Technically for another
Yeah.
We just won't.
Yeah,
month or so.
that's why I just wanted to throw that out there in case
Couple months.
anybody didn't realize that you were still active here for a while.
October 28th, I think, is it?
And Nick, kind of for the record, so do we have a second person that's then filling one of these slots, or do we have to?
It's Thunder Frost, it's the second.
It's Frost, okay, thank you.
Okay, so I have an amendment to recognize that the expiration of the policy committee or the board term does not automatically terminate
Their membership on the ARC.
That they can finish out their term on the ARC.
But then next time I wouldn't be eligible unless I was on another committee for some reason.
Yep. Okay. Any other questions or discussion regarding the rule language? Okay. Then a short comment on the fiscal impact statement, and that there was, DPSST did not find a fiscal or economic impact identified with the administrative rule change. So with that being the conclusion of prepared comments, I would return it to the committee for the action items that are on page 3. So with this one, the vote, so the consensus on the fiscal impact statements, but then the vote on the recommendation to the board would be including the amendment piece.
Thank you, Jennifer. So the first action item is the consensus. So do we affirm that the fiscal impact statement as prepared, which there is none, so I'm assuming that we're all okay with that. I'll make that assumption. And then the vote would be to have a motion to accept the rule changes and then the modification about if we're on the committee, and then they can finish up the ARC term, and that's it.
Josh Aldridge, for the record, I would move that we recommend the board adopt the language with the suggested amendment.
Totally, sorry.
Okay, thank you. So we have a motion.
Right, we are voting on a motion to recommend the board approve filing the proposed rule changes with the amendments discussed for OAR 259-006-0010 as a permanent rule. Vice Chair Cameron?
Aye.
Committee Member Aldrich?
Aye.
Committee Member Boren?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartman? Committee Member Hunter? Aye. Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Tabor?
Aye.
Motion passed.
Okay, thank you. Next, Jennifer will be up again regarding proposed rule changes for Oregon Administrative Rule 259-008-0085.
Can I just, oh, for 1 second, it's Maria for the record. Erica, are you, do you need to do anything with Juan so that you can switch? Are you leaving?
I have 25 minutes, so
Okay.
I can do just one more.
Just wanted to check.
Yeah,
Go ahead.
I can give them the last ones.
All right.
Okay, go ahead, Jennifer, next.
Thank you, Jennifer Howell, for the record. Chair Hunter, Vice Chair Cameron, members of the committee, DPSST identified a need to add more clarity to the rules and processes that guide how and when a student is required to make up missed training. DPSST refers to this process as a form of remediation. So through this discussion, you may hear me say remediation or make up missed training interchangeably. Per rule, all students are required to complete the basic training course to meet the minimum standards for certification. This includes completing the course in its entirety and meeting the student performance measures such as testing and skills demonstration. However, it's important to recognize that there may be circumstances that result in student absences. Those could include such things as court appearances, illnesses, and injuries. There are also circumstances when the department has to modify a course schedule to address things like severe weather conditions and instructor scheduling. Over time, DPSST noted differing interpretations of the rule language, which resulted in inconsistent outcomes related to the absences, course schedule modifications, and completing missed training. After reviewing the rule history and current practices to determine how to clarify the rule and its interpretation moving forward, DPSST identified the following key points. All missed training must be remediated. This includes absences and training and training schedule modifications that result in missing training. Some remediation can be completed in less time than the hour-for-hour class schedule. So where you need 4 hours to instruct 30 students, you may only need 3.5 or 3 hours to do one-on-one instruction with an individual to make missed training. However, there are still topics and skills that will necessitate the hour-for-hour makeup. And the academy will make sure that that occurs for those specific classes. But underlying all of this is the essential requirement that the public safety officer receives the full breadth of training content included in the board-approved courses. Staff don't have discretion on determining whether mistraining requires remediation. It's just that all training must be completed. The rule changes are shown on pages 2 and 3, and as you can see, there's a fairly extensive expansion of the existing rule. Again, this is meant to add clarity and codify current policies for a consistent application of the rule in the future. I want to note that section 20 and subsections 20A and 20B apply to all students, meaning the DPSST Academy students and the DOC Basic Corrections BCC students. Subsection 20C adds the processes that apply to the DPSST Academy students. Because DOC is delivering the BCC course to their employees, they retain the discretion on the process by which they handle remediation of mistraining to satisfy subsections A and B above. So before I move on to the fiscal impact statements, I wanted to pause for questions or discussion related to any of the proposed rule language.
Kind of for that, so just for clarity, Jennifer. So if DOC is doing it differently, what we don't get away from is the training objectives, and those training objectives have to be met. How DOC chooses to meet those training objectives when it comes to remediation, that's the part that's up to them. And potentially there would be inconsistencies between DPSST and DOC and how they deliver that.
Thank you, Jennifer Howell, for the record. In part, there will be differences because of the nature of delivering training at the academy versus delivering training within your institution. So what we're saying is that what we've outlined in C as DPSST's process, DOC is welcome to follow that if they choose to, and apply to some of those same concepts. The underlying requirement is that all training is remediated, it's all documented, and it's all shown. So whether or not, how they choose to apply when they're doing the remediation in time, so while the person is currently engaged in the course, or whether they have to come back and modify it and do it later, just as DPSST would. They just hold the discretion on how they're applying that.
And I thank you, and I think too, we have some people online who have some questions, or is Bill has his hand up. It looks like the other one took their hand down. So,
John, did you want to go first? And I'm happy to follow up after you go.
Actually, I
we're
think yeah,
gonna
I
say
think
the same
Jennifer
thing.
actually, yeah. Yeah, I think Jennifer covered, and that is the current and ongoing practice in DOC has been that every class is remediated anyway. 90% of the time, that means that they're coming back to the next class. And when they can be remediated on the fly, we do that, but that's rare. So most of the time, they just come back to another class. So we're getting 100% completion out of everybody on our end.
And Phil Castle, for the record, I just wanted to add a little bit. What's important to us, there's three things that are really important. Number one is safety. So we're not going to compromise safety ever, and that's one of our guiding principles at DPSST. Number two is quality. So we want to make sure that every trainee who's coming through the academy is getting the required training they need to start work on day one. And that's really important. Number three is customer service. You're our customers, and it's really important to us that we're not making you jump through any hoops that you don't need to. So we've expanded our regional remediation abilities. So whenever possible, we will go out to the customer to remediate in place if possible. We will do that. We do everything we can to not have to bring the person back to the academy or to repeat a class unless it's absolutely necessary, because we know that's time and money and resources for agencies out there. So I just wanted to add that in.
thank you.
Jennifer, Catherine McAlpin for the record. Other thing I'd like to just call out is kind of the check and balances of DPSST, and that's why we have our certification side and maintenance. They're the ones that look at the notebooks, make sure we're following policies, making sure that we have remediated that 10%. They work very closely with training, came up with this language so that there is consistency in the interpretation. We also know there's gonna have to be communication out to our constituents, because I think the creep out there that's gone is if maybe a student says, I've got court, oh, that's within your 10%, you don't have to make it up. And so we'll do some communication to make sure that everything is made up. It's just how we do it and the magnitude of the lead that we have to make up. But again, that's the internal workings that go on to make sure that we are providing the best quality and safety for all the students here.
Thank you. Do you have anything else, Jennifer?
I have the fiscal impact statement when you're ready.
Okay, go ahead.
All right, thank you. So the fiscal impact for these rule changes is indeterminate. There's always been a fiscal impact to DPSST and the employing agency when making up this training. The processes that are codified in this rule are not expected to have an effect on the costs that are associated, those pre-existing costs. But the clarifications to the rule may result in an initial increase in the number of remediations that occur. The fiscal impact statements in the memo outline several factors that contribute to what those indeterminate costs could be. And to summarize, they include staff time to coordinate and deliver makeup training, whether the training can be made up while at the academy. If the remediation occurs after the academy, there are additional employer factors such as scheduling and geographic location. DPSST, as Director Castle mentioned, recently implemented a policy that allows makeup training to be conducted locally to help offset those travel costs and conduct remediations on a more timely basis. But there's then the counter impact to DPSST regional training workload. Your memo also includes a list of entities that were identified as potentially impacted by the rule change. And that includes essentially any state agency or local government that employs public safety professionals. To include state agencies such as Oregon State Police, Department of Corrections, the Oregon Liquor and Cannabis Commission, the Board of Parole and Post-Prison Supervision, the Department of Justice, and the Oregon Judicial Departments. For cities and counties, that's the police departments, sheriff's offices, dispatch centers, and community corrections agencies. This could also potentially impact our tribal governments with public safety officers certified by DPSST, Oregon Health Sciences University, and any other public universities with police departments. We did not identify fiscal or economic impacts for members of the public, and there were no small businesses identified. And that's the overview and the prepared remarks, and happy to take any additional questions.
Thank you, Jennifer. Any other questions for her?
One quick one, Nick Hunter for the record. I can't remember, the LMS package went through. And so although there is a fiscal impact to the LMS package, that could help to offset some of these remediation costs depending on what the class is.
Yes, thank you, Jennifer Held, for the record. That's an accurate statement, but because that is still so far into the future for, so we've got the approval to pursue the LMS, but we still have to procure and implement it. I don't think it would have an impact on the rule change at this time. But in the future, yes, it can be used as a tool to, or it could be used as a tool to help deliver the remediation mistraining makeup.
Josh Aldridge for the record, not a question, but as a representative of one of those geographically located agencies, I just want to say that any focus is appreciated in the remote training opportunities. I think it's a really valuable avenue to pursue for those of us who are spending a day or more if we have to return to the academy for just a couple hours of class. So.
Thank you. So we have action items on this. The first being the consensus to affirm or amend the fiscal statement as prepared. Consensus. So we will accept it as prepared, so thank you. Then, the second action item is to make a motion to recommend to the board to approve the filing of the proposed rule changes to this OAR as a permanent rule.
Nick Hatter, so moved.
To
Make a
make
motion
the-
to approve.
Okay, thank you. Jennifer Cameron, I'll second. Do we have a motion to recommend this become?
Yes, so we are voting on a motion to recommend that the board approve filing the proposed rule changes for OAR 259-008-0085, section 20 as a permanent rule. Vice Chair Cameron?
Aye.
Committee Member Aldridge?
Aye.
Committee Member Boren?
Aye.
Committee Member Bowden?
Aye.
Committee Member Frasco?
Aye.
Committee Member Frost?
Aye.
Committee Member Hartford?
Aye.
Committee Member Hunter?
Aye.
Committee Member Langley?
Aye.
Committee Member Mays?
Aye.
And Committee Member Tabor.
Aye.
Motion passed.
Okay, thank you, Jennifer, as always. That's some good information. Next, agenda item 15, which is an overview and summary of changes to the basic parole and probation curriculum, and Christy Hess is here to talk about that.
Hi, Christy Hess for the record. It's the second time before you guys, I think, so some familiar faces and some new faces. Good to see everybody. I am a part of the Center for Policing Excellence team. My role on that team is the curriculum coordinator, so part of my duties is overseeing program revision and curriculum updates. I'm here today with Jason Ridgway.
Jason Ridgway for the record. I've been with DPSST now for well over 4 months, and have been assigned to the basic parole and probation program as a coordinator. So I've been keeping up with the revisions as they've been made and voicing some input, and so talking about what those look like and how it impacts our students.
Great, thank you. So the basic parole and probation program was identified as kind of our next big project. The main focus of that request was to get the Senate Bill 1510 mandates sort of formally and intentionally included into that program. Those concepts had existed in that program already, but this gave us an opportunity to pull some work groups together and very specifically and intentionally create time and space and scope for that conversation as it related to the field of parole and probation. So the first step in that project for us was to develop a kind of a larger oversight work group, which involved about 17 constituent member involvements that were selected from across the state. We used that larger work group as sort of our formal approval sign-off group to any proposed content for those mandated topics. In addition to that larger work group, we formed 3 smaller focus groups that did most of the consideration and what content needed to be included and how did that sort of classroom engagement kind of come to life. All of that work was sent through a larger work group to approve, to propose. The focus group members were created by a statewide survey that we sent out last August in 2024, asking for identified parole and probation staff and some community members and what they would be interested in participating to, what experience and expertise they could provide to that group, ensuring that those focus groups were representative of the state perspective, different years of experience, some field training officers, just being really intentional about how those groups were formed. We partnered with those groups and really developed some pretty strong and sound course goals and core topics. A lot of that aligns with what other program areas are doing to meet those course needs in other disciplines. You have some material before you today, one of which is the memo, which is a really kind of high-level overview of some of the recommendations as far as our increases and reductions. When we came away from that process with the focus groups and the work groups, it was identified that Trauma was kind of, could stand alone as a class, and to meet the outcomes that those groups proposed, we would need about 4 hours in order to do that. The de-escalation class, you won't see as a standalone on that list. Part of our sort of reconsideration of those course topics was to align concepts like de-escalation into like a communication series. We've gotten feedback from students that they have a really hard time making connections between class concepts and are intentionally integrated. And so we took a class like de-escalation, which is traditionally standing on its own as a class, and just weaved it into the communication series. So we'll teach you all these communication skills. What are the barriers? How can you find success with cooperation? Tone and volume, body posture, all that stuff. And then we finally get to the part that goes, great. Now how does that change when you're dealing with somebody in crisis? And so hopefully that continuity of that conversation allows for students to more tangibly connect concepts and then intentionally build and like complexity of those concepts as we move through that series versus having it kind of stand alone on its own. In order to meet the culturally responsive services mandate, one of the focus groups spent considerable time kind of talking about what were the skills and knowledge that that group might need in order to offer services that are sort of specific to the individual outside of the crime that they've committed. And so that class will show up, how that's represented in the curriculum on that breakdown. Will be the cultural humility class, which was a 4-hour proposal, and then subconscious thought, which has traditionally been called like our bias series. Again, trying to just adjust language for students to just increase their kind of acceptance and openness to conversations. So those 8 hours between those two classes with some specific student learning activities within those to address the special populations conversation that had been happening with a little bit more specific focus on kind of cultural responsivity and diversity. The summary of changes document that you have is a little bit more detailed breakdown of some of that rationale behind some of the decisions in order to create space for the hours that we identified as being needed to achieve the outcomes of the mandates. We needed to really do a complete audit of the program and figure out where can we align topics, where can we condense, right, and merge concepts in order to create space to work within the 200 approved hours that we had. So that summary of changes gives a little bit more detail into where did some classes go. Some just merged classes with title changes and no impact on hours. But that kind of rolls over into the large document, the curriculum overview document that really is a significant comprehensive hour goal topic breakdown of everything that we're kind of proposing in its future state. Another impact of these proposals would not just be the content sort of adjustment and hour breakdown, but would also significantly impact parole and probation's structure design, their kind of class schedule. We're hoping to align that program with other programs like we've done with police and corrections, where we're taking the long blocks of training time and reducing them into shorter, more manageable sort of loads for students. That allows us to sort of intentionally connect concepts and build on complexity, creating shorter, more frequent sessions within that program. So that would be a change to the structure of the BPP program. And then the final assessment that on the memo you'll see represented in the administrative hours, in addition to the administrative hours, was one of the big recommendations that the larger work group had was re-implementing the academic assessment through a quiz, 2 quizzes and a final was sort of the proposal that was made. There was an identified gap with that group in feedback on students leaving the academy, that the current projects and assignments weren't sort of comprehensive enough to evaluate real student learning here, and so their proposal was to bring back the exams as sort of a measure of their performance. What that would look like on our end would be, we have a learning and assessment coordinator who would have to craft, 80 to 100 new questions in order to meet that need. One of his big focuses is ensuring the validity of the test by piloting several versions before we start making decisions off of students pass or fail here based off those exams. So the proposal would be that we sort of pilot test for 3 to 4 classes, which for the pro and probation program takes a couple years to, if we have attendance and full classes, to kind of get the data that we need to make sure that we're have done a good analysis of those before we start making certification decisions off of those new exams. So that's the other kind of big push. That recommendation was put before OACCD in July with no sort of discontent or pushback on that. So it's possible to recover some hours from project time if needed while we kind of test run that process before finalizing an hour adjustment for the needed time for those exams. So all of these recommendations have been evaluated and developed by subject matter experts. Not a whole lot of new content in there outside of the mandated curriculum. Reflects current best practice in research and student learning, and hopefully is enhancing sort of their retention and transfer of that knowledge that they get here when they get out into their agencies. So unless we can answer any questions that people might have, we ask for approval on the recommendation of the updates to the Pro and Probation Basic Training Program.
I have a question. So
Yes.
when we get to the approval, is it the memo that this memo that we're making the approval, or, because I'm not seeing any other documents besides, well, then we have this. So is this?
That's the comprehensive curriculum overview, which is
the one that.
Yeah,
okay.
our topic, that stamps and sort of scopes what we're allowed to do within each course.
And that's what we would recommend if we had a motion, the changes in that. Okay, thank you for clarifying that with me.
Josh, I'll just for the record, question about that document based on our previous conversation with remediation hours. I see that several of these mention that they would not need to be remediated. So I'm just curious how that matches with the
Yeah, this
decision that was
document
discussed.
was pre any conversation on our end about
Sure.
the rule change, so that could probably get in and get adjusted and changed and fixed. That was still built off the old 10% requirement.
Kind of for the record, and I don't know how deep I want to go into this, because I don't know how deep you two want to go into this. It's hard for me to look at, I'm looking at like the hour sheet and what we're doing. You specifically talked about de-escalation. De-escalation is much more than a communication skill. And so I don't know that looping it into communication is sending the right message to our folks, nor do I know if it is actually incorporating human performance into what that looks like. And I don't want that to get locked into that it is only a communication skill, because there are 2 people involved in a de-escalation situation, and sometimes communication is not even possible. So if we're sending the wrong message that you can de-escalate your way verbally out of anything, that actually doesn't work. And I'm not saying that we are, but that's what's hard for me to see in this is how does that de-escalation then work into scenarios, and what are we doing in scenarios? I'm hugely in support of exams coming back. All the latest research supports that exams are actually helping with retention. They don't do anything with transference, but they help with retention, so that's a good thing. But are we doing recognition? Are we doing recall? How are we breaking up those tests to achieve? And I hear what you all are saying, that it's gonna take a couple years of like rolling those things out. So I looked at my commander a second ago and I asked him, and I was like, hey, are you in support of this? And Mike says yes. So every part of me says, not that I don't trust the 2 of you, but I trust him because I know him way too well, that I'll be in support of this to move it. Is there any way I could see more deep into how this was constructed as opposed to just the output that you're sharing with us now?
Yeah, so Christy has for the record. So we met with our use of force coordinator and actually ran the de-escalation content through him to align some of the conversations in that crisis peak when your communication strategies, all of your best laid attempts have failed. Can we align that crisis response as far as safety and time to what use of force is talking about with their safety and time considerations. And so there was collaboration and input from that coordinator. We can surely craft a different maybe outline or summary of some of that. That was one of the considerations when developing that course, was that the de-escalation conversation had always lived in silo of kind of communication and or use of force, and we have really attempted in this program with this rewrite to align that language in those conversations as opposed to talking about it in different ways in all of those courses.
I get that trying to weave it in and where does it fit best and how do we do that, because it involves multiple skill sets that go into de-escalation. One of the things is we believe that we can teach de-escalation in 2 hours in a room, and it has nothing to do with transference, and none of these skills will transfer. And you all have the very tough job of teaching to the lowest denominator, and I don't mean that in skill level. What I mean that in is agency size, and some of the folks that are coming to you, you are the only training that these folks are gonna get. And so what does that product look like going out the door? And where do we get to transference? Because everything that we're doing here is all closed environment. It's not open environment training, and that chasm that exists between the rule and the tool, and we teach the rule and the tool, we don't teach the context. So this is why I said I don't necessarily want to open my mouth and get into this, because I'm not sure this is the room to get into it. So I'll defer to my commander. My commander says he's happy with what this looks like, and so I'm okay with where this goes, and I know how to get into other channels to poke into things if I want to.
So Jennifer Kemmer, for the record, when Sheriff Hunter is talking about communication, I do agree with him. So still in the use of force section, they're still gonna have the de-escalation tactics and all of those things in there. Okay.
This edition, has actually aligned that language in those
Okay.
conversations
Gotcha.
versus creating something that has traditionally lived in sort of the behavioral health specialist world, and really tried to, maybe for the first time, really bridge that language and align that so that they're hearing it in de-escalation and communication as a part of that, and using the same language that our use of force experts are using when they're talking about verbal commands and warnings in the use of force program. So we would hope to see a clearer understanding and a larger connection between communication skills and physical skills, and that kind of continuum of that by design.
All right, thank you.
Josh Eldridge for the record. I see a reduction in career-life balance, and then I see that it's moved to resiliency, but I don't see resiliency in the final.
So resiliency wasn't impacted by hours, so it maintained its hour allotment. We just took the outcomes, which were a little bit repetitive to what the resiliency series had anyways, and just incorporated the conversations about the profession and the weight of that profession into the conversation about how to
What is
find-
that series called on this document?
In that document, it's in resiliency. It won't be on the memo because it wasn't impacted by hours. It wasn't additioned, didn't have additional hours or didn't reduce any hours, so it doesn't make that
It was just
summary of
wrapped in.
changes. Right, it's in the larger curriculum overview document under this alphabetically organized.
Okay. So I think then our action item is to make a motion if we want to approve the changes to the basic parole and probation curriculum as presented.
And Director Castle would like to speak.
Oh, thank you.
Phil Castle for the record. You know, there is a good reason why the board approves all of our curriculum. And I am super proud of CPE and what they do and what Christy and team do. If there are board members who are wishing to dive deeper into this, we will absolutely make that available. And we're happy to do that. And it's important that you understand what we're doing in those classrooms. You know, we represent you, but you also represent us. So we're happy to do that. And I don't think you're diving too deep.
Thank you.
Ted Langley for the record, not trying to belabor a point, but Member Aldridge brought up the resiliency piece. I still don't see it. I'm not seeing it anywhere.
Hartford, for the record, in the 200-hour course breakdown is in the alphabetical list. It's in.
I think it's in the document after the memo.
This document.
It's it's in color, but it's
How did it explain? I don't have that document.
In the previous tab.
I'm sure it was part of the package, but I didn't bring it. I have everything.
Well, we would, we're sure we'd open the feedback as we're getting familiar with the different versions of communication and what kind of information is put in what document, what would be helpful to this committee, and other communication about not enough, too much, how is it organized, and is that the best way to get it to you guys? You guys have a lot of material to review in a very short amount of time, so we can surely discuss better ways to maybe package that.
One of the big issues you have is the legislative side, and you don't have enough hours to work with.
Right.
That's your problem.
Right.
Is anybody willing to
That's
make
okay,
a motion?
I'll make a motion now, after I just said everything else. I'll make a motion that we approve the changes to the curriculum as presented to us both in written and verbal form today.
Thank you.
Ted Langley for the record, second.
Okay, so we have a motion to approve the changes to basic parole and probation.
We're voting on a motion to recommend that the board approve the changes to the basic parole and probation curriculum. Vice Chair Cameron?
Aye.
Member Aldridge?
Aye.
Member Boren?
Aye.
Member Bowden?
Aye.
Member Frasco?
Aye.
Member Frost? Member Frost?
Aye.
Member Hartford?
Aye.
Or Chair Hunter? Aye. Member Langley?
Aye.
Member May?
Aye.
And Member Tabor?
Aye.
Motion passed.
Okay, thank you. We appreciate it. Okay, only 3 agenda items left. On to number 17, which is proposed rule changes for OAR 259-008-0085, which has to do with basic parole and probation curriculum as well. Jennifer.
Thank you, Jennifer Howell, for the record. This was a quick one. This is the technical implementation of your recommendation to the board to adopt the new parole and probation curriculum. So what you see is a rule change that recognizes the future board approval date of October 23rd, 2025. So we're updating the rule to acknowledge what our current curriculum will be based on and that approval, and it codifies that in a timeline so that when we look back and to know which version of curriculum is the correct version, we know that this is the correct version. You'll see as you turn over to page 2, we've added the technical information regarding to the statutory requirements that parole and probation basic training include those 3 topics, which is training providing trauma-informed care, culturally specific services, and de-escalation techniques. Again, that came from Senate Bill 1510 in the year 2012, and that's reflected in Oregon Revised Statute 181A.530. We included, just so that it's there, the language that addresses the student performance measures. And as indicated in the curriculum review, the student performance measures and the field training manual, they'll stay the same for now as we implement the new course, and then they take the next steps to review what changes need to be made within the field training manual, and then once they've had a chance to pilot the examination process, once the examination process is complete, we'll come back to you at a later time to change those student performance measures through a rule change. So that's the rule language portion of it. Of course, with every rule change, you also have a fiscal impact statement broadly, DPSST didn't identify anything that is expected to have a fiscal impact on a law enforcement agency that employs a parole and probation officer. We did identify in the statement what's added, what's removed, and then there were no impacts identified for the board, for the public, and there were no small businesses that are impacted by this. There's also the notation there that as we roll this out and communicate it, we want to make sure that everyone understands we're not, if the length of the course doesn't change, we're still conducting it in the 5-week course in the approximate 200 hours. So happy to answer any questions about the rule or the no fiscal impact statement.
Any questions for Jennifer? Online at all? I don't see any hands. Okay, so we'll move on to our action items, I do believe. The first one is a consensus to affirm or amend the fiscal impact statement as prepared. I think I'm good with that. Everybody? Okay. So the consensus is to affirm that. The second would be a vote by motion to recommend to the board to approve the proposed rule changes in OAR 259-008-0085 as permanent rules, if there's no substantive comments received. Jennifer Cameron, I'll make a motion to approve.
Marlon, no second.
Okay. We have a motion to approve.
All right, we're voting on a motion to recommend that the board approve filing the proposed rule changes for OAR 259-008-0085 as a permanent rule. Vice Chair Cameron?
Aye.
Member Aldridge?
Aye.
Member Boren?
Aye.
Member Bowden?
Aye.
Member Frasco?
Aye.
Member Frost? Member Frost?
Aye.
Thank you. Member Hartsford?
Aye.
Chair Hunter?
Aye.
Member Langley?
Aye.
Member Mays?
Aye.
And Member Tabor?
Aye.
Motion carries.
Okay, thank you. I think we're at 18 now for agency updates. Director Castle, I think you're up, or are you, Kathy?
Yeah, and I'll try and be quick, and I'm going to pass it off to Kathy and Marie when I'm done. So Phil Castle for the record. You heard Sheriff Hunter say that we got the LMS as part of our legislative session, which is true. We did. That's very exciting. We're starting to lean forward now on preparing for the procurement process for that. We also received money for a few other things, which is really nice for us. First, we sustained our current service level, which included the additions from the last biennium to be able to function at the level that we are now and to be able to run 60-person classes for basic police when necessary, which is really great. We needed to do that. We also got money that crossed over from last biennium into this biennium to repair our F building, otherwise known as our main street in the village, which has some substantial structural damage from internal wind shear that the building was never designed to withstand. It is going to need structural repairs, and we did get the money to do that, and we're right in the middle of taking bids from contractors at this moment to start the work. So we're excited about that. We got $3.4 million of deferred maintenance, which is fantastic because we have somewhere in the neighborhood of 12 million that needs to be done to our various buildings and structures. 3.4 million is great. And we're going to be able to do a lot of really emergent things that we need to do on the campus and keep ourselves above water. We also got $500,000 to be able to do a campus study and to make improvements to prepare the campus for construction and more buildings as we grow. And we need to grow, as you all well know. So that's what's going on at a legislative session. That's what we're real focused on right now in terms of preparing for these very big projects. We're a little agency, but we do mighty things, and we're going to be focusing on those here shortly. I wanted to, I normally do this first, and I want to make sure I do this because this is important. I want to thank you all for being here. This is a big commitment of your time, and we're over time right now, which I apologize. Again, I'll try to keep this short. But your commitment and you being here is appreciated as I see Vice Chair Cameron stack her library of books out there. I know that's a huge commitment to go through all those, to read all of those, and I'm super grateful for your willingness to do that. So thank you very much. I'm also grateful to the staff that are sitting there in the room who put so much time and effort to prepare this, and the professionalism that they put behind this. So thank you so much to all of you for the work you do to prepare for this. The OER designates me, or the director of the agency, and it is right here. It is 181A-385. That designates me as the secretary of the board, or my designee. And in this case, and in all cases of the board and the policy committees, that designee will be Marie Atwood. And I'm just kind of stating that for all the policy committees and the board, just for the record. Kathy and I have recently got into an organization that Chair Hunter, by the way, congratulations, Chair Hunter. And thank you, Vice Chair Cameron, for all your service here and continued. I appreciate that. Kathy and I are heading to FLETC, the Federal Law Enforcement Training Center in Georgia, next week, and we will be participating in a IATLIST meeting, and I'm just going to continue with this acronym, the International Association of Directors of Law Enforcement Standards and Training. And it's basically all the academy/posts that are around the country coming together to compare notes, to talk about best practices, to talk about instructor development, to talk about current trends. We're meeting in Georgia at FLETC to do that. And it's been really healthy for us to engage with these other organizations. And I'm going to tell you, we are one of one. There is nothing else out there like us. And we are very fortunate to have what we have, even though we need to grow. I'm still grateful for the buildings and the programs and the funding that we have, but we are one of one. And there are many states that struggle to control and to standardize and to do the things that we do. And not taking anything away from the great state of Texas, but they have 120 academies in Texas. And I talked to the post director there and asked him how he controls the standardization and curriculum there, and he just kind of tapped his head, and his head is bald like mine. So it's quite a challenge. So I'm super grateful for that. And does anyone have any questions of me before I turn it over to Kathy Marie? Hearing none, I turn it over to the better of the two of us, Deputy Director Kathy McAlpine.
Thank you, Bill. Kathy McAlpine for the record. I get to bring the joy into this room of recognizing Mark Bourne for his 4 years on CPC and ARC. And now that we've confirmed, Mark, that you will be still serving on ARC, which I appreciate. But we thank everybody for this. You come in with your subject matter experts, your viewpoints, but it's so important to have the public member to kind of do a check and balance, to see what we do. You don't hesitate to bring your voice to the conversation. It is appreciated. And thank you so much for your service. My pleasure. And I'll give you your letter and your certificate. One thing else I'll add is through IATLIS, they have an accreditation program both for their post and their academy. We are going to embark on that process. We're going to, as recommended by IATLIS, is to do the academy first, and then the post will be your standards and training. So we're just getting ready to start the self-assessment, and then we'll see how we're situated and see how long it takes us to hopefully get accredited by IATLIS. So throughout the time, Phil or I will keep you updated on our progress. But we're pretty excited to see how we compete and meet with best practices. Marie?
Thank you, Kathy. Marie Atwood for the record. I don't have much other than to say thank you to everybody for hanging in there during this lengthy agenda today. Congratulations to our new chair. And I would like to introduce Ben Hamilton, who left the room. He's already hungry and didn't want to stick around. No, he's going to be our new criminal justice program manager. So he will be supervising the team that does all of that background work to get us to these meetings. You know, all of the volumes of materials that we send to you come from that team, and they do a ton of legwork to make sure that the work that we do here is all completely squared away and dialed in. So thank you to my team. You will all be getting to know Ben in the coming months, and yeah, that's all I have for today.
Thank you. So I think, well, since I'm chair today, I do want to